La Cour Please be seated. Good morning. I declare open the public hearing on the admissibility in the case of Ukraine and the Netherlands versus Russia. The case brings together three separate interstate applications which were joined by the Grand Chamber on 27 November 2020 pursuant to Rules 42 paragraph 1 and 71 paragraph 1 of the Rules of Court. The first two applications were lodged under Article 33 of the Convention, respectively on 13 March 2014 and 13 June 2014, namely Ukraine versus Russia number 1, regarding allegations of violations notably in eastern Ukraine, and Ukraine versus Russia number 2, regarding the alleged kidnapping and transfer to the Russian Federation of 3 groups of children and accompanying adults. The third application, the Netherlands versus Russia, the MH17 application, was lodged on 10 July 2020 regarding the downing of flight MH17. Prior to this, the first two applications were initially allocated to the third section pursuant to Rule 51, paragraph 1. On 13 March 2014, the President of the latter decided in respect of the first application to indicate an interim measure under Rule 39 calling upon both Ukraine and the Russian Federation to refrain from taking any measures, in particular military action, which might entail breaches of the Convention rights of the civilian population, including putting their life and health at risk. On 13 June 2014, the President of the third section decided in respect of the second application to indicate to the government of Russia under Rule 39 that they should ensure respect for the Convention rights of the persons concerned and their immediate return to Ukraine. Having regard to the information provided by the Ukrainian government that the children had been returned to Ukraine on 26 June 2014, the interim measure was lifted. On 20 November 2014 and 29 September 2015, a chamber of the third section requested the government of the Russian Federation to submit observations on admissibility. The cases were subsequently reallocated to the first section. On 7 May 2018, a chamber of the first section decided to relinquish jurisdiction in regard to the cases in favor of the Grand Chamber. The MH17 application was lodged, as I mentioned before, with the Court on 10 July 2020 under Article 33 of the Convention by the Government of the Netherlands and was initially allocated to the first section. Subsequently, following the Grand Chamber's above-mentioned joinder of the three applications on 27 November 2020, the Government of Canada, the Human Rights Law Centre of the University of Nottingham, the applicants in the cases of Ailey and others versus Russia, Anglin and others versus Russia, Baker and others versus Russia, and Varta and others versus Russia, all of whom are relatives of most of the victims of Flight MH17, and the MH17 Air Disaster Foundation in the Netherlands, representing those relatives, were granted leave to intervene as third parties in the MH17 case. The government of the Russian Federation are represented by Mr. Mikhail Vinogradov, representative of the Russian Federation at the European Court of Human Rights and head of the General Department of International Legal Cooperation. He is assisted by Mr. Denis Grunis, Senior Assistant of the General Prosecutor of the Russian Federation for Special Affairs. Mr. Alexander Deviatko, Deputy Chief Military Prosecutor. Mr. Anastasia Khamenkova and Ms. Yulia Afanasieva, both Senior Prosecutors at the Department for the Operation of the Representative of the Russian Federation at the European Court of Human Rights and the General Directorate of International Legal Cooperation are also representing the Russian government. The government of Ukraine are represented by Mr. Denis Malyuska, Minister of Justice of Ukraine. He is assisted by Mr. Ben Emerson, QC Counsel, Ms. Valeria Kolomiets, Deputy Minister of Justice of Ukraine on European Integration, Ms. Margarita Sokorenko, Deputy Head of the Office of the Agent before the European Court of Human Rights, Ms. Oksana Kolomiets, Head of the Unit for Representation of the Government in cases regarding the temporarily occupied territory of Donetsk and Luhansk regions, Mr. Peter Hood, Counsel, Ms. Anne O'Reilly, Counsel, and Mr. Ivan Lishina, Advisor at the Ministry of Justice of Ukraine. The government of the Netherlands are represented by their agent, Ms. Babette Holtman, assisted by Mr. René Lefebvre, Legal Advisor at the Ministry of Foreign Affairs, Ms. Lisbeth van Heest, Coordinator Task Force MH17 at the Ministry of Foreign Affairs, Ms. Anne Achten, Legal Officer at the Ministry of Foreign Affairs, Ms. Robin de Ruyter, Advisor to the Minister at the Ministry of Justice and Security, and Mr. Piet Ploch, Chair of the Foundation Air Disaster MH17. I welcome the representatives in the name of the Court. Having consulted the representatives of the government, I have determined the order of addresses as follows. Mr. Vinogradov for the government of the Russian Federation will speak first, then Mr. Malyuska and Mr. Emerson for the government of Ukraine, and then Ms. Hopman and Mr. Ploch for the government of the Netherlands. Each party will have 45 minutes to plead their case. Mr. Vinogradov, you have the floor.
Thank you. Mr. President, esteemed judges, today an extremely complicated case on the interstate applications of Ukraine and the Netherlands against Russia is to be heard before the Grand Chamber of the Court. The case concerns a large number of events which took place on the southeast of Ukraine and which are very complicated and were investigated fragmentarily or not investigated at all. We regret that the Court decided to reject the request of the Russian Federation to join consideration of the present applications with the application of Russia against Ukraine. In our view, such joining would be in the best interest of the efficient administration of justice. The events of the case to be heard today go hand in hand with the interstate application against Ukraine. Moreover, inevitably, we will turn to the criminal proceedings pending before the District Court in The Hague in respect of the 4 suspects of downing of the Malaysia Airlines MH17 flight. Undoubtedly, this case deserves special attention, and I regret that today we have only 45 minutes for each party to present the arguments. Now, on behalf of the Russian Federation, I will present our case. And the case clearly and convincingly evidenced that the Court should refuse to consider the applications of Ukraine and the Netherlands on the merits for a wide range of reasons. First, in my presentation, I will cover general considerations according to which actions described in the applications against Russia obviously do not fall within the jurisdiction of the Russian Federation in the meaning of Article 1 of the Convention. Secondly, I will present the arguments on the basis of which the application of the Netherlands should be declared inadmissible in its entirety. Then I will proceed to the arguments upon which the application of Ukraine on the alleged violations of the provisions of the Convention by Russia in connection with the displacement of orphan and disabled children from the territory of Ukraine to the Rostov region of the Russian Federation is manifestly ill-founded and should be dismissed. In conclusion of my presentation, I will illustrate the reasons which evidence that application of Ukraine on the alleged violations supposedly committed by Russia on the territory of Donbass is not subject to consideration on the merits by the court. Once again, because of extremely limited time allocated to us, I will focus on the main points and arguments of the applicant states only. And I trust the esteemed judges of the Grand Chamber will be able to consider the submissions of the Russian Federation in entirety and the evidence in support in the written materials previously presented. So I will start with the arguments of the lack of jurisdiction of the Russian Federation. The authorities of the Russian Federation draw the attention to the fact that the events described in the applications of Ukraine and the Netherlands, even if those happened, took place in the Donetsk and Lugansk regions of Ukraine, that is, outside of the Russian Federation. We recall that in its Bankovich and others' decision, the Grand Chamber unanimously held that jurisdictional competence of a state is primarily territorial, and therefore, as a general rule, the states cannot be found responsible for their extraterritorial actions. We agree with this approach of the Grand Chamber and encourage to come to the same conclusion in the present case. Russia is not responsible under Article 1 of the Convention for the events set out in the applications of the Netherlands and Ukraine. Furthermore, the authorities of the Russian Federation strongly disagree with the application of effective control concept as stated in the applications. We recall that effective control concept was at the time created specifically for assessment of the particularities of cases in northern Cyprus. It never was designed as a universal instrument for establishment of jurisdiction of a member state. The case under consideration differs from Molesidu and Cyprus versus Turkey cases. Russia does not exercise effective control on the territory at issue, neither directly nor through the armed forces or the controlled local administration or its support by the Russian authorities. As it follows from the case file, according to the statement of the head of staff of the Ukrainian armed forces, Colonel General Mr. Viktor Muzhenko, at the material time, there were no regular military units of the Russian armed forces on the territory of the Donetsk and Lugansk regions of Ukraine. I would like to pay your attention to the fact that despite the statement in their application lodged with the court, the authorities of the Netherlands also do not consider events in Ukraine as an international armed conflict with participation of the Russian Federation. With due attention, we follow the trial in The Hague, and we would like to underline that the prosecutor's office of the Netherlands, in the indictment in respect of 4 persons, specifically indicates the absence of international armed conflict on the southeast of Ukraine, and as a consequence, the lack of the combatant status of the accused persons. Prosecution clearly admits that otherwise those should be cleared of all charges. There is no credible evidence of supplying weapons from the Russian Federation to Donbass. All we have in the case are only rumors, fakes, and highly likely allegations. By the way, the militiamen note in open sources that there are enough Ukrainian weapons in Donbass. Herein further, I also will draw parallels to other state and quasi-state formations to support our argument that the concept of effective control is not applicable. Any assumed economic influence of Russia on the southeast of Ukraine also does not lead to the success for application of Article 1 of the Convention. Even if we theoretically assume that Russia provides financial, including humanitarian assistance, to the self-proclaimed Donetsk and Lugansk People's Republics, on the other side of this medal is the European Union and its member states, as well as other countries, did provide critically vital financial support to Ukraine, and they keep on doing. I recall the recent note of Mr. Borrell that the European Union rendered to Ukraine the financial aid in the amount of 17 billion euro in total. Is it effective control as well? The European Union structures actively take part in the coordination of the state budget of Ukraine. The applicant states in their applications claim that administrative appointments in specific districts of the Donetsk and Lugansk regions of Ukraine are conducted with approval of the Russian authorities. Once again, I noticed that it was not in any way confirmed. In the meantime, let us turn to the proven facts. It is the state bodies of Ukraine that are created with the active participation of the so-called external experts from the European Union and the United States. As we can see, self-proclaimed Donetsk and Lugansk People's Republics take permanent measures on adoption and improvement of their own legislation, which is different from the Ukrainian one. With all transparency, self-proclaimed authorities conduct such actions following the example of Russia. This is true. And by accepting Russian standards on the territory of the legal vacuum, let's call it in this way, the result of such actions is indirect dissemination of principles and standards of the Council of Europe and the fundamental principles of democracy over the territory. This element illustrates in its turn the need to exhaust effective domestic remedies on the territory of Donbass in the public authorities of the unrecognized state entities. The analogy with the Dimopoulos case is absolutely appropriate here. However, this element of the effective control does not fly systematically either way. As we know, legislation of Ukraine itself on the key sectors of economy is elaborated and adopted under the external guidance and control of the European Union. Statement of Ukraine that substantive part of Donbass population obtained nationality of the Russian Federation also apparently should entail the conclusion on effective control of some other states like Romania and Hungary over particular areas of Ukraine in which the states actively conduct issuing their national passports to local population. Thus, based on the criteria indicated by the applicant states, in different historical periods, even some other countries like Bosnia and Herzegovina, Kosovo, Ukraine, maybe some others, also should fall under this concept. Is it still the case? Is it applicable here for us? We feel that no. I regret to recall that even since the delivery of Ilashku and Katan judgments by the Grand Chamber, it became evident inter alia that holding Russia responsible on the ground of the effective control concept was erroneous, and the judgments themselves were rendered clearly unenforceable. With due regard to the said, we believe that the Grand Chamber, for now, has the best opportunity to reconsider the effective control concept and to come to the only appropriate conclusion on its inapplicability to the present case. In any case, we draw the Court's attention to the fact that the circumstances described in the applications take place in the course of an armed conflict in Ukraine. As the Grand Chamber of the Court indicated in Georgia against Russia judgment in the second case, in the event of military operations, including, for instance, armed attacks, bombing, or shelling, carried out during the international armed conflict, one cannot generally speak of effective control over an area. The very reality of armed confrontation and fighting between enemy military forces seeking to establish control over an area in the context of chaos means that there is no control over an area. We recall that the Grand Chamber attached weight to the fact that the very reality of armed confrontation and fighting between enemy military forces seeking to establish control over an area in the context of chaos not only mean that there is no effective control, but also includes any form of state agent authority and control over individuals. As indicated by the Court, the contracting states involved in the armed conflict outside their territory do not exercise jurisdiction on this territory in the meaning of Article 1 of the Convention. And all supposed substantive violations of any provisions of the Convention in the zone of active hostilities do not fall within the scope of the Convention. The authorities of the Russian Federation insist that Russia is not the part of the hostilities in Ukraine. However, if the court, for some reason, still decides to examine the responsibility of the Russian state in Donbass, in order to implement the Convention, the said principles should be taken into account, and the allegations contained in the applications of the Netherlands and Ukraine should be dismissed. The authorities of the Russian Federation note that the state agents concept is also inapplicable to the present case. I would like to draw your attention that, as noted in the Öcalan judgment, in order to establish the jurisdiction of one state on the territory of another in the absence of effective control, it should be convincingly proven that individuals located on the territory of this other state are under the power and control of the first state through its agents. In the applications of Ukraine and the Netherlands concerning the events in Donbass, such facts are not only described as established, but they are absent at all. There is no confirmation that particular actions were taken by representatives of the Russian state or upon their command. The reference to the pro-Russian militiamen is clearly not enough for the application of the state agent concept. On the basis of the above said, I declare that Russia does not bear responsibility under Article 1 of the Convention in respect of the circumstances specified in the applications of Ukraine and the Netherlands. Now I turn to the Netherlands versus Russia application in more details. Undoubtedly, the crash of the MH17 flight is a great tragedy. Together with the whole world, we mourn and we express sincere condolences to the relatives of the passengers and the crew who died in the air crash. At the same time, I regret to note that the said application is based on distortion of facts, forged evidence, on assertions not corresponding to reality, and sometimes even fakes. As we can see, the application of the Netherlands consists of three main elements. First, on an unfounded accusation of Russia that it bears responsibility for this airplane crash. Second, on the allegation that Russia refuses to conduct effective investigation upon the facts of the airplane crash. And third, directly arising from the second, on the claim that Russia allegedly refuses to fulfill its obligations to cooperate in the framework of providing mutual legal assistance and extradition. First of all, the authorities of the Russian Federation insist on their non-involvement in the airplane crash and in no way admit their responsibility for the occurred incident. The tragedy of MH17 flight happened in the active phase of hostilities of the civil war in Donbass. It is still argued, and no investigation has evidently and finally established who exercised control over the territory upon which the airplane of Malaysia Airlines was shut down. The only certain fact is that this was the airspace of Ukraine, where the air traffic was managed by the Ukrainian air traffic authorities. We follow attentively the course of the trial in the District Court of The Hague, and we know that according to the clarifications of the court-appointed expert, Mr. Mikhail Malishevsky, the alleged missile launch took place on the territory under the control of the Ukrainian armed forces. And the warhead, which in view of the joint investigation team downed the airplane, belonged once again to the armed forces of Ukraine. As it follows from the case file, before the air crash, Ukraine constantly conducted the artillery shelling and airstrikes. For instance, on the 22nd of April 2014, an Antonov aircraft of the Ukrainian state aviation was shut down in the airspace of Ukraine. On 14th of July 2014, that is just 3 days before the tragedy, an Antonov transport plane of the Ukrainian Air Forces was shut down in the Lugansk region, and 2 crew members died. During the specified period of active hostilities, 15 more military aircrafts and helicopters of the armed forces of Ukraine were downed. Taking into account the foregoing, and in no way admitting the responsibility for the occurred air crash, I invite the Grand Chamber to be coherent, and like in Georgia versus Russia, the second case, to come to the conclusion on the lack of responsibility on the ground of Article 1 of the Convention in respect of the Netherlands' claims under Articles 2 and 3 of the Convention in their substantive aspect. In any case, we draw the Court's attention that this part of the application of the Netherlands obviously lies outside the 6 month time limit for its submission to the Court, and therefore it must be rejected. The argument of the Netherlands that there are some exceptional circumstances for which the 6 months rule does not apply is clearly unfounded, and its presentation is more than vague. We request the Grand Chamber to reject this part of the application either as manifestly ill-founded or, in any case, as lodged outside the 6 month time period. The authorities of the Russian Federation note that the Netherlands provided the Court with the application on which the investigation by the investigative body of any foreign state is not yet completed. Not a single court of a member state of the Council of Europe delivered a final judgment on the case. The proceedings in the Court of the Netherlands nowadays is far from termination. From the outset, we disagree with the effectiveness of investigation of this crime by the Joint Investigation Team. Meanwhile, the authorities of the Netherlands accuse Russia for the lack of effective investigation of the downing of MH17 flight, which could have established the victims and the perpetrators. In this connection, I would like to draw attention of the Court that according to point 3 of Article 12 of the Criminal Code of the Russian Federation, foreign citizens and stateless persons who permanently not reside in Russia who committed a crime outside the boundaries of the Russian Federation are subject to criminal responsibility upon the Code in cases if the crime is directed against the interests of the Russian Federation or a citizen of the Russian Federation or a stateless person permanently residing on the territory of the Russian Federation, as well as in cases provided for by the international treaties of the Russian Federation or other documents of international nature containing obligations recognized by the Russian Federation in the sphere of relations regulated by the Criminal Code. We remind that when the Russian nationals were accused of crime in the Netherlands, the Russian Federation sent request to the competent authorities of the Netherlands to transfer the case file in order that the Russian investigative authorities perform investigative actions and, if appropriate and necessary, criminal prosecution. This request was submitted timely, and it was reasonable since it was submitted immediately after the Joint Investigation Team announced the names of the accused during its briefing. However, this request was refused. As the Ministry of Justice of the Netherlands explained, investigation of the case within the Dutch jurisdiction would have been more appropriate. Thus, the statement of the Netherlands that Russia violated its obligations under the Convention lacks any sense, since it is the Netherlands who prevents investigation on the territory of the Russian Federation. We also bring attention to the fact that no request to the Russian investigative authorities to initiate criminal case under the procedure prescribed by the Russian law was ever lodged with regard to the airplane crash. All this proves that the application of the Netherlands on allegedly ineffective investigation with the reference of Article 2 of the Convention is manifestly ill-founded and should be dismissed due to the non-exhaustion of the domestic remedies. Turning to the claim of the Netherlands concerning the alleged lack of effective domestic remedies in the Russian Federation under Article 13 of the Convention, as we can see, the Netherlands submitted mutually exclusive statements on Russia's alleged breach of the obligation to conduct an effective investigation and at the same time on the absence of the effective investigative remedies in practice in Russia. In any case, the part of the application under Article 13 of the Convention is not supported and is unsubstantiated and therefore is manifestly ill-founded. For now, I will turn to the alleged violation of obligations under the Convention within the framework of provision of mutual legal assistance on criminal cases. In accordance with the well-established court's case law, an obligation to cooperate under the procedural limb of Article 2 of the Convention is an obligation of means, not the result. We invite the Grand Chamber to consistently follow this approach in the present case as well. Unfortunately, the authorities of the Netherlands clearly mislead the court that the Russian authorities left requests on legal assistance unanswered in full or in part. I feel it's necessary to inform the court that by the present time, 29 requests for legal assistance from the Netherlands were received, and 28 of them were executed, while the remaining one is still pending. None of the legal assistance requests of the Netherlands was left without response. In their application, the authorities of the Netherlands expressed dissatisfaction with the content of the given answers. In this connection, I declare that the Russian Federation transferred volumes of materials concerning the Malaysia Airlines crash on paper as well as in digital form. Questions remain as to why investigation did not get use of these materials and why some pieces of evidence, as for instance Almas Ante report, were classified and were transmitted to the joint investigation team and revealed only in 2021 when the case was already heard before the District Court of The Hague. Probably this evidence didn't fit in the version of the investigation which determined the Russian Federation to be guilty in downing the MH17 flight well in advance. But these questions should be addressed to the competent authorities of the Netherlands themselves. What is most striking in the allegations of the Netherlands? It is the allegation that Russia didn't extradite the citizen of Ukraine, Mr. Vladimir Tsemach. I would like to recall that Mr. Vladimir Tsemach was kidnapped by the Ukrainian law enforcement authorities and carried under fire across the frontier line from his home in Donbass to Kiev. Mr. Tsemach was interrogated for several times by the members of the joint investigation team in Kiev in his witness status. As we know from the open sources, in August 2019, the authorities of the applicant state requested the competent bodies of Ukraine not to transfer Mr. Tsemach to Russia, calling him the valuable witness. The exchange was still carried out on the 7th of September 2019. What is most striking in this respect is the request of the authorities of the Netherlands for arrest and extradition of Mr. Vladimir Tsemach on the basis of the European Convention on Extradition. Any expert has a simple question to raise. How one can request extradition of a person who has a witness status in the criminal case? And it is not the end of the story. As the situation with the request was not clear for us, two unnecessary requests for clarification by the Russian Federation, as the authorities of the Netherlands put it, were sent. When the clarifications were received, it was found out that the Dutch prosecutor lied to the competent Russian authorities about the existence of the arrest warrant of Mr. Tsemach, because it didn't exist. Later, in trial before the District Court of The Hague, the prosecution, still mixing and confusing about the procedural status of Mr. Tsemach, specifically acknowledged that the evidence to bring charges against him was not enough. I believe that no further comments are necessary on this point. The authorities of the Netherlands required from Russia to fulfill the extradition request in breach of the requirement of their own legislation and the relevant international legal instrument. In view of the foregoing, I invite the Grand Chamber to dismiss this part of the application of the authorities of the Netherlands as manifestly ill-founded and, alternatively, on account of the abuse of their right to lodge an application with the court. Now I will turn to the application of Ukraine concerning the transfer of children from Donbass to Russia. So those three events took place on 12th of June, 26th of July, and 8th of August 2014. And the authorities of the Russian Federation point out that this application should be declared inadmissible as manifestly ill-founded, as well as in accordance with the non-exhaustion of the effective domestic remedies. First of all, the facts and the circumstances of this case do not indicate the violation of the Convention on account of voluntary transfer of children and adults accompanying them, which was done solely for the purpose of saving children's lives and health. This statement is also confirmed by the guarantee letter of the Ukrainian Consul General in Rostov-on-Don, Mr. Moskalenko, which states that the consular office took responsibility for the safety and health of the children. Anyway, the application under consideration is inadmissible due to non-exhaustion of the effective domestic remedies. In the first case, on the 12th of June 2014, the Ukrainian Consul General in Rostov-on-Don, Mr. Moskalenko, filed a written complaint on the commission of crime with the investigative body of the Russian Federation. However, representatives of the authorities of Ukraine show no further interest in it. In the second and third cases of the children's transfer, there were no complaints to the investigative authorities as such. Consequently, the application of Ukraine must be rejected as inadmissible. Regarding the facts covered by the application of Ukraine concerning events in Donbass, the authorities of the Russian Federation reiterate that they do not recognize their jurisdiction and state that all elements of the Ukraine's complaint concerning events on the southeast of Ukraine should be declared inadmissible. Meanwhile, we would also like to draw attention of the Grand Chamber to further grounds under which the application should be dismissed. In relation to the alleged violation of Article 4 of the Convention, the authorities of Ukraine refer to the administrative practice of involvement of the so-called prisoners of war to forced labor by militiamen, not by the authorities of the Russian Federation. Without acknowledging its responsibility, the Russian Federation, in respect of the alleged violations, stress that the authorities of Ukraine provided no specific facts which could be considered as administrative practice. The application contains only references to the report of the Office of the High Commissioner for Human Rights and Special Monitoring Mission of the Organization for Security and Cooperation in Europe, which do not evidence consistency and frequency of the events allegedly taken place. The applicant state, in principle, failed to submit evidence in support of existence of the violation of Article 4 of the Convention in the present case within the application. In any case, the indicated events are covered by the period which is outside the 6-month time limit started from the moment of the statement by the authorities to the court. The Russian Federation also do not see the attempts aimed at exhaustion of effective domestic remedies. In this respect, we suggest that this application is inadmissible in its entirety and therefore should be dismissed. Furthermore, the authorities of Ukraine refer to inacceptably broad terms to the alleged violation of Article 9 of the Convention in connection with persecution of members of any confession other than the Russian Orthodox Church. Close study of the application shows that allegations of Ukraine are aimed at the protection of the rights of believers of the Ukrainian Orthodox Church, of the Kiev Patriarchate, and of the Ukrainian Greek Catholic Church. Nevertheless, we find no statements on the fact of infringement of rights of those of the said confessions in the case file of the application. The only religious community which, as it follows from the submitted materials, which was supposedly repressed, was the followers of the Jehovah's Witness. However, we do not find the evidence of such repression in the application of Ukraine. No facts of persecution of priests were indicated or found out either. Consequently, the application in this part should be declared manifestly ill-founded. The authorities of Ukraine also point on violation of Article 11 of the Convention in connection with the restrictions on political activity and persecution of politicians by the authorities of the self-proclaimed Donetsk and Lugansk People's Republics. At the same time, no particular statements were provided about specific actions which convincingly could prove that the same proclaimed authorities obstructed political activity. In the application, we can only find allegations that political activity was essentially restricted in spring 2014. I draw your attention that the authorities of Ukraine submitted the relevant claims in August 2015. Thus, this part of the application in any case should be dismissed as inadmissible in connection with the non-compliance of the 6-month time limit for its submission. As to the allegations concerning prohibition of discrimination, the authorities of the Russian Federation remind the well-established court's case law, according to which Article 14 has no independent existence and cannot be used in isolation and may be only claimed in conjunction with other provisions of the Convention and protocols to it. In this connection, since the application of Ukraine on the said article was lodged separately from the substantive provisions of the Convention, it should be declared inadmissible. I remind that the Russian Federation have not ratified Protocol 12 to the Convention either. As to the right to education, the alleged violation of which the authorities of Ukraine refer to as well, examination of the present case file shows that Ukraine did not adduce a single fact in support of a violation of the right to education. The application contains no particular examples of persecution of teachers in connection with their professional activity or the oppression of students. In addition, there are no facts of closure of any educational institutions which could have had the aim to restrict the right to education. On another point, with reference to the Paxos judgment, the authorities of the Russian Federation also note that this part of the application concerns the alleged violation of the citizens' right to participate in free presidential elections in Donbass, and thus is incompatible rationa materia with the provisions of the Convention, and it should be declared inadmissible as well. In conclusion, taking into account the above said, the Russian Federation invites the court to reject the applications of the authorities of the Netherlands and Ukraine in their entirety. We are ready to answer the questions of the judges of the Grand Chamber today or further on as to be decided, and to submit the materials in support of the arguments we have presented today. Thank you very much.
Thank you, Mr. Vinogradov, for your submissions. I now turn to the government of Ukraine. Minister Malyuska, you have the floor.
Your Honor, Mr. President, honorable members of the Court. I'm the Minister of Justice of Ukraine, and I'm here to deliver to you the position of my government on the present matter. I consider this a single most important court case in my career as a minister, and probably one of the most prominent litigations in the history of Ukraine, and thus I consider it important that I personally appear before the court to represent Ukraine in this case. I would like to start my address by reminding the Court that the first application brought by Ukraine in the context of the aggressive war which Russia launched against Ukraine was filed on March 13, 2014, and it concerned the Russian military occupation of Crimea. At the time, it appeared that the case would concern an outrageous but exceptional and territorially limited occasion of the Russian aggression. However, the subsequent events proved that the Russian appetites towards Ukraine were only inflated by the occupation of Crimea. Less than a month after Russia secured its effective control over Crimea, that it had launched a new campaign in April 2014 aimed at occupation of the eastern and southern Ukraine. It did not even put much effort into hiding its participation in the dramatic events of the spring 2014 in cities of the eastern and southern Ukraine, using the same traveling circus of professional separatists, such as Girkin, Bezler Pavlar, Motorola Nufriev, in both Crimea and Donbass hostilities. This list could be continued. However, I'm not here to give you the detailed account of the Ukrainian case on Russia's effective control over occupied territories of Luhansk and Donetsk regions of Ukraine. What I'm saying is that Ukraine is suffering not from a separate instances of the Russian aggression and the mass violation of the convention rights associated with them, but with a consistent long-term policy of the Russian Federation aimed at bending Ukraine to the Russian interests and swaying it away from its path towards Western values and civilization. This policy continues up until now. Russia attempts to achieve its goal via various forms and methods. Most recently, it has amassed enormous forces along the border of Ukraine, threatening the invasion and all-out war in order to prevent Ukraine from joining NATO and becoming immune to the threats of this kind in the future. What is peculiar about the current situation and relevant to the matter in the hands is that Russian authorities, exemplar gracia Vice Speaker of the State Duma, Mr. Kosachev, openly claim that Russia would see itself entitled to invade Ukraine if the latter would move its army against DPR and LPR. It is beyond the point that Ukraine does not intend to resolve the DLPR issue by force. What is important here is that such threats by themselves demonstrate the effective control Russia exercises over the DLPR. It also shows that with South Ossetia, the Russian program of generous partization of the inhabitants of the regions under its control is aimed at providing Russia with a cause to invade independent states whenever it feels like it. In the context of the looming Russian invasion into Ukrainian territory, the behavior of the Russian government toward the hearing in the present case appears sinister. I would remind the Court that the hearing was initially fixed for November 24, 2021. The Russian government on many occasions attempted to disrupt the hearing, seeking its postponement on the pretext of the Russian COVID measures and filing an ill-prepared application against Ukraine, seeking its joining to the present proceedings. When these attempts proved ineffective, and the Court refused to adjourn the hearing on November 8, 2021, 16 days before the hearing and roughly 3 years after his appointment, the Russian ad hoc judge suddenly discovered circumstances that could compromise his impartiality, which forced the court to reschedule the hearing for today. In late November 2021, the concentration of Russian troops around Ukraine was at its infant stage. Whilst we cannot know for sure that the ad hoc judge followed any orders from the Russian government, not that the Russia's efforts at postponement of the hearing were somehow related to the potential military aggression against Ukraine. However, here we are, represented Ukraine in Strasbourg, whilst Ukraine is facing a threat of invasion by fully prepared Russian army of over 100,000 servicemen. I invite the Honourable Court to take into account this context when considering the Russian objections to the admissibility of the present application. And now I pass the word to Mr. Ben Emerson, QC.
Mr. Emerson, please.
Mr. President, members of the Court, these interstate applications concern a grave and continuing pattern of convention violations carried out on Ukrainian sovereign territory since 2014. The evidence overwhelmingly demonstrates that these violations were perpetrated directly by members of the Russian military and intelligence services and their proxies in the separatist movements in eastern Ukraine, and that they were perpetrated on territory that was fully under effective Russian control. The victims included prisoners of war and civilian detainees who were under the effective control of their captors as well, so that both limbs of the extraterritoriality test are potentially in play. In its 2016 resolution on the situation in eastern Ukraine, the Parliamentary Assembly of the Council of Europe described the pattern of violations for which Russia stands credibly accused as including, quote, extrajudicial executions, enforced disappearances, torture and inhuman and degrading treatment, unlawful detentions and disproportionate restrictions on the freedom of expression and freedom of information. That is the parliamentary body of the Council of Europe. The victims of these violations included journalists, students, politicians and members of civil society. They are united by common characteristics, their Ukrainian ethnicity and their actual or perceived support for maintaining Ukrainian territorial integrity. As we shall hear further from the government of the Netherlands, the victims also include the 298 civilians killed in the attack on Malaysian Airlines MH17, a civilian aircraft flying in civilian airspace, shot from the sky by agents of the Russian Federation using a missile provided directly the day before by the Russian military and bussed across the border for the purposes of discharge and fired from Snizhny territory under the effective control of the separatist entities that relied upon Russian support for their continued existence. In these proceedings, the Russian government maintains its position that it has never had any direct involvement or presence in eastern Ukraine, still less any responsibility for human rights violations which took place there. Russia maintains that the allegations, including the reports of a UN High Commissioner for Human Rights, are concocted as part of a global conspiracy, and that in fact Ukraine should be held responsible for any human rights violations committed in territory outside the government's control by Russian separatists supported by the Russian government, provided not only with finances and political support, but direct military intervention and military supplies. The Russian Federation maintains this fiction that any Russian serviceman identified or captured behind the border, in other words, on the Ukrainian side of the border, were, quote, tourists, a familiar euphemism used for thousands of Russian service personnel who are actively and have been actively engaged in the military activities of the separatists throughout this period, or that they accidentally got lost and strayed across the border. These explanations are vague and risible. Russia is once again gaslighting the international community and trying to gaslight this court in a posture that amounts to a denial of justice and accountability to the many thousands of victims of these human rights violations, victims who continue to be denied any effective remedy by the Russian Federation or its subordinate authorities. The allegations made by the government of Ukraine are serious and credible and advanced in good faith. The evidence of Russian state responsibility assembled in Ukraine's filings to this court easily surmounts the evidential threshold which is applicable on this court's jurisprudence at the admissibility stage in an interstate case. The test, of course, is whether the allegations made by Ukraine are genuine allegations made in good faith. Notwithstanding the denials and diversionary tactics deployed by the Russian government, these allegations are plainly made in good faith and demand a thorough examination on the merits. During his submissions, Mr. Vinogradov, on behalf of the Russian Federation, repeatedly argued that aspects of the case, and indeed the case as a whole, should be dismissed as being manifestly ill-founded. Well, Mr. President, members of the Court, you will know full well that the Court has repeatedly rejected the manifestly ill-founded test as a ground for admissibility in an interstate proceeding. There is simply no equivalent of that test or of minimum evidential threshold to be overcome. The test is simply, are the allegations made in good faith, and do they meet the technical requirements of jurisdiction, timing and so on. But to the extent that the Russian Federation is under the impression that there is some kind of evidential threshold that needs to be overcome, we would respectfully submit that that is plainly wrong. But even so, we would respectfully submit that the evidence here is overwhelming on all of the issues, and that the way in which the matter is being presented by the Russian Federation is misleading, and deliberately so. Mr. President, as this Court is undoubtedly aware, the hearing takes place in a context of acute tension between Russia and Ukraine. It's already been noted that more than 100,000 Russian troops are currently poised on Ukraine's northern and eastern frontiers, ready to mount a land invasion as soon as the order is given. Military hardware, including tanks, self-propelled artillery and armoured vehicles, have been moved to within striking range of Ukraine's territory, including its capital, Kiev. On this occasion, however, Ukraine is much better equipped and much better prepared than it was in 2014. Europe therefore stands on the brink of a bloody and protracted armed conflict, more serious than any that has occurred on the continent since the Second World War. We would remind the Court that when Russia invaded Georgia in 2008, the invasion was followed by what this chamber has held to have been a campaign of ethnic cleansing by Russian forces and their proxies. It is more important today than perhaps it has ever been before that this Court should send a clear and unequivocal message to the Russian government that it will not be deceived by gaslighting and obfuscation, and that Russia will be held legally accountable for violations of the human rights of those people that fall within its jurisdiction. Mr. President, with that introduction, let me turn first then to the question of Article 1 jurisdiction. From Ukraine's perspective, Russia has exercised extraterritorial jurisdiction under Article 1 since, at the latest, the end of April 2014. This is based on Russia's effective control over territory, as evidenced primarily by the presence of Russian military personnel and weapons on Ukrainian territory, and secondly by its military, political and economic support and influence over its subordinate administrations, the so-called Luhansk and Donetsk People's Republic, which depend on Russian support for their continued existence, the test that the Court itself has laid down in numerous cases. It is also based on the exercise of physical power and control by Russian agents, including military and intelligence staff, and Russia's proxies, over the victims of human rights violations alleged. So both bases. In Georgia versus Russia number 2, this chamber held that the very short period of intense fighting which took place between the invasion by Russian forces on the 8th of August 2008 and the withdrawal of Georgian troops from South Ossetia on the 12th of August, that during that period, such a context of chaos, quoting the court's judgment, prevailed as to render it impossible to determine which side was in effective control of the relevant territory during that period. Accordingly, the Grand Chamber held that during intense and active hostilities, where the control of the territory is disputed, the doctrine of the effective control of territory cannot clearly be applied. It cannot be applied with clarity. It is not difficult to understand why the court reached that conclusion, and Ukraine accepts the same legal test is to be applied to the facts here in determining effective control of territory. But the court in Georgia also held that the doctrine of effective control over the victim by state agents could not apply during intense hostilities either. And the logic behind this second limb of the test in Georgia and Russia is a bit more difficult to understand. If an invading force takes prisoners during an intense military engagement, those prisoners should not be deprived of their convention rights, especially their right not to be subjected to torture. Accordingly, Ukraine submits that this second limb of the intense hostilities test in Georgia-Russia cannot deprive prisoners of war or civilian detainees of their convention rights, even where they have been captured during the course of intense hostilities. As regards the first limb of the test, Russia established effective control over Donbass in April 2004 through a state-backed coup against the legitimate authorities. In tab 1 of the file that has been submitted, you will have a series of contemporary maps of the areas that were controlled at different times, and these were compiled by Ukrainian armed services during the conflict itself. And to the extent that it may be helpful during the course of the question session that follows, I will refer to that, from which you will be able to see with relative clarity where effective control was completely established and where there were areas in which control was disputed at any given time. I hope that they will be a useful starting point. So we say Russia established effective control over Donbass in April 2004, while there were subsequent changes in the contact line following advances and temporary control by the Ukrainian troops, and periods during which the conflict sharply intensified in certain areas, including in particular the Battle of Ilovaisk, which I'll come back to. This all took place on territory which had, since April 2014, been under the control of the Russian Federation. The facts of the present case are therefore completely different from the situation in Georgia, Russia, where the 5 days of intense conflict immediately followed Russia's invasion of territory previously held under Georgian control, Georgian sovereign territory under the full control of the government. Indeed, the situation in eastern Ukraine is, for the purposes of determining jurisdiction, indistinguishable from the situation in Crimea following the Russian occupation on the 27th of February, and the situation in South Ossetia and Abkhazia after the 12th of August 2008, circumstances in which this chamber has recently ruled that Russia exercised effective control. From as early as January 2014, members of the Russian Duma were present in Donetsk, organising would-be separatists into paramilitary formations. In March 2014, as Russia sought to consolidate its control over illegally occupied Crimean Peninsula, Russian agitators were bussed into eastern Ukraine to participate in riots. During these riots, government buildings were seized, and Ukrainian civilians deemed hostile to the agenda of the pro-Russian separatists were violently attacked. The Russian government pretends that this was a spontaneous uprising of concerned Ukrainian citizens, But this is demonstrably false. In intercepted telephone calls from March 2014, verified by expert photoscopic evidence, President Putin's aide, Sergei Glaziev, congratulates pro-Russian separatists for occupying government buildings in Donetsk and talks of a formula for providing military support to the separatists based on seemingly spontaneous appeals to the Russian Federation for assistance. Meanwhile, in circumstances reminiscent of those which prevail today, Russian troops amassed on the Ukrainian border, creating the spectre of a massive and imminent military invasion. On the 9th of March 2014, the Parliamentary Assembly of the Council of Europe estimated that there were 26,000 troops on the Russian side of the border and warned Russia against, quotes, further unprovoked military aggression against Ukraine. But undeterred, Russia sent more troops. By the 9th of April, NATO Secretary-General reported that on the basis of satellite imagery, there were now some 40,000 Russian troops amassed along the border. Not, he said, training, but ready for combat. At the same time, President Putin made overtures to would-be separatists in the course of his regular phone-in show in order to foment the rebellion. In relation to events in eastern Ukraine, he said this: "This is Nova Russia. Kharkiv, Luhansk, Donetsk, Kherson, Nikolaev and Odessa were not part of Ukraine during the Tsarist times." So President Putin, and one can see this in the essay he wrote last June, which is on the government's website for all to read, that there is nothing in the justification about the threat from NATO, nothing about retreating as far as Russia can retreat, and everything about the notion that Russia should re-establish its boundaries in the Tsarist times. In other words, going back to pre-revolutionary Russia and suggesting that large parts of its near abroad actually belong to Russia. And one heard the remarks that were made on behalf of the government just a moment ago, when it was suggested that the Donetsk-Luhansk region was in some kind of legal vacuum. That was the word, the expression that was used, a legal vacuum, as though it were terra nullius in international law. But it's absolute nonsense. It's part of the sovereign territory of Ukraine, in which there is a separatist movement fanned, financed and resourced by the Russian government with a view to creating the notion that there is some free-floating part of Ukraine that really truly belongs to Russia. And that's entirely consistent with the universal passportization, so that Russia can claim these citizens as its own. It's effectively annexation by stealth. The formula by which support was provided, the deliberate ferment of unrest, public appeals to a sense of historical ethno-nationalism among Russian minorities, and the provocation of calls for assistance from these groups as a pretext to military intervention is nothing new. It's a staple of Russia's foreign policy towards states in its near abroad. The same formula was used to prepare the ground for Russia's invasions of South Ossetia, Transnistria, and most recently Crimea. Ominously, it is the same formula which Russia appears to be deploying today. Against that backdrop, in early 2014, heavily armed separatist militias began to seize government buildings in cities across eastern Ukraine, raising Russian and separatist flags as they went. The evidence shows that these militias included and were in many instances led by Russian military and intelligence personnel. Perhaps the most prominent of these figures was FSB agent and protagonist of the Russian occupation in Crimea, Igor Girkin, who went by the nom de guerre Strelkov, or Shooter. In these proceedings, the Russian government seeks to disown Mr. Gherkin, claiming that he retired from the FSB in 2013. Whether this is true or not, it does not affect the role which he played on Russia's behalf in consolidating effective control between April and August 2014, nor, as I will come to demonstrate, his direct role in perpetrating egregious human rights violations in the region as an agent of the Russian Federation. Gherkin would later describe in a media interview how he led a contingent of men, including special forces from the GRU, or the main intelligence directorate of the Russian armed forces, from occupied Crimea into eastern Ukraine. On the night of the 11th and 12th of April, this contingent occupied the city of Slavyansk, capturing an administrative, police and council buildings. They come from Crimea, into which they had been sent by the Russian Federation, and then bust the contingent up to the Donbass region, where Gherkin became a key military and political leader of the separatists. The buildings that they seized, and in particular the basements where perceived opponents of the Russian separatists, including 10 monitors from the OSCE's monitoring unit, were unlawfully detained. Those basements were the site of some of the most horrific human rights violations in the evidence. By the end of April, as you can see from the maps in tab 1, cities from Novoazovsk on the Sea of Azov to Siversk, some 250 kilometres to the north, including the principal cities of Donetsk and Luhansk, had fallen into the hands of the Russian-backed separatist paramilitaries. They declared the formation of people's republics in Luhansk and Donetsk and established parallel, illegitimate governance structures. At this point, the acting Ukrainian president was forced to announce that Ukraine was no longer in control of the territory. Again, there was nothing spontaneous about this seizure of the territory. It was, in the words of the US State Department, coordinated and professional. Even at this early stage, denials of Russian involvement, in the words of then British Foreign Secretary William Hague, lacked a shred of credibility. Intercepted telephone calls and emails from May 2014 reveal the extent of Russian control over the so-called DPR and LPR and their associated paramilitary formations. On the 1st of May, Vladimir Putin's special envoy, Vladimir Lukin, called Gherkin to give instructions on the release of the OSCE monitors being held in Slavyansk. This cannot, as Russia seems to suggest, be characterised as a dialogue between officials aimed at gathering information about events close to Russia's border. It was an operational instruction from the Russian president's emissary with, in his words, verification from the highest level delivered to an agent of the Russian state operating inside Ukraine. This is the presidency giving orders on the management of the situation on the ground inside Ukraine in the Donbass region. Contrary to Russia's representations to this court that it played no role in political appointments in the DPR and LPR, intercepted communications also reveal the tight grip which the Kremlin exercised over the leadership of these entities. Vladislav Surkov, another senior Putin aide, often referred to as the Grey Cardinal, in recognition of the influence he is said to have with the president, received lists of recommendations for posts in the government of the so-called DPR. According to Gherkin himself, figures such as Alexander Borodai, the Russian-born Prime Minister of the DPR from May 2014, were appointed and removed at the Kremlin's pleasure. So the man who was responsible for beginning the process and the early political and military leaders himself has attested to the fact that the appointments of political leadership to these two entities were at the sole control of the Kremlin. In June 2014, as the Ukrainian government deployed its military and air force in a counter-terrorism operation in eastern Ukraine, further intercepted phone calls reveal increasingly desperate requests by the paramilitary leaders for further support. In one such call, on the 8th of June, Gherkin says quite clearly that the separatists depend for their continued existence on Russian military support. He says, and I quote, "If the issue of Russian support, air cover or at least artillery support is not dealt with, then we will not be able to hold ground here in the east. No way." Although perhaps not always to the extent that their separatist leaders wanted, the Russian government answered positively to these requests for military support. During the month of June 2014, the Ukrainian Ministry of Defence recorded the crossing of 56 Russian tanks and 24 armoured vehicles, along with artillery, ammunition and other military equipment from the Russian Federation into the Ukrainian territory. Again, for your assistance, tabs 2, 3 and 4 in the bundles include a number of documents selectively put together, but as illustrating the extent of Russian military hardware seized or used inside Ukraine on the various points in the conflict. Tab 2 is a reconstruction of a seized tank, which puts it beyond any doubt that the tank is Russian, not for example, Ukrainian or any other source. And if you click on the link that's referred to in that document, I think you'll find it a very helpful guide to how these identifications are made. During the same period, June 2014, OSCE observers report seeing convoys of military hardware, including tanks and armoured personnel carriers, travelling from the direction of the Russian border, and OHCHR observers reported seeing armoured personnel carriers in the streets of Donetsk. Apparently in response to evidence submitted by Ukraine showing that the Russian T-90A tanks had been used inside Ukraine, and that's linked to tab 2, the Russian government commissioned an expert report to try to suggest that images of these tanks had been manipulated, but even its own experts could find no evidence to support that position. What the evidence does show is that Russian men and military hardware were transported across the international border and onto Ukrainian territory. Again, in an intercepted phone call between Borodai and another separatist leader on the 27th of June, Borodai has reassured that there are 54 Marines arriving from the Far East, a well-knit formation including officers up to Lieutenant Colonel. By the 14th of July at the latest, the prosecutor of the International Criminal Court informed the UN Security Council that there was sufficient evidence of direct military engagement by Russia's armed forces inside Ukraine and the presence on Ukrainian territory of Russian military hardware to indicate the existence of an international armed conflict in eastern Ukraine alongside the non-international armed conflict. In other words, by the 14th of July, the ICC prosecutor was telling the UN Security Council that Russia was a direct, on-the-ground protagonist inside eastern Ukraine, such that the conflict was to be regarded as an international armed conflict. The Russian government denies this, maintaining the fiction that it was a spontaneous uprising. It denies that any weapons have been supplied across the border, and it denies that Russian military personnel were present in eastern Ukraine. However, the Russian written submissions do not seriously even attempt to engage with the overwhelming body of evidence proving this position to be false. Even the Russian president has struggled at times to maintain the fiction that there were no Russian military personnel in Ukraine, conceding, as he did in 2015, in an interview in 2015, "We never said that there are not people there handling certain questions, including those in the military sphere, but this does not mean that Russian regular troops are present." The court should afford, we say, the court should afford this fiction no greater credibility than did the Parliamentary Assembly of the OSCE on the 2nd of July 2014, when it adopted the Baku Declaration, condemning Russia's, and I just quote again, egregious violation of Ukraine's sovereignty and territorial integrity, and deploring, quote, the armed intervention by forces under the control of the Russian Federation in Ukraine and the human rights violations that they continue to cause. In this context, the court must examine the killing of 298 civilians on board Malaysian Airlines MH17. The Russian government contends that it could not have jurisdiction over the incident because there was no effective control over the relevant territory and no control by agents of the state over the passengers on board. However, as the joint investigation team has amply demonstrated, the missile was fired from territory under the control of the defence minister of the so-called DPR, Igor Girkin, by forces under his direct command and control. The Buk-Teller missile system, which was used to launch the surface-to-air missile, was transported at Gherkin's request from Russia, specifically from the 53rd Anti-Aircraft Missile Brigade of the Russian Armed Forces, and returned to Russian territory shortly after the incident. All of this, as you know, is captured on a series of videos and satellite images and other photographic images from which it is possible to trace the vehicle's movements directly from before it left the 53rd Anti-Aircraft Missile Brigade's headquarters on the Russian side of the border until it returned there after the attack, all of which took place within a 48-hour time period. On that basis, there can be no serious doubt that Russia has jurisdiction over the incident under Article 1, whether on the basis of effective control, state agent authority and control, or, as we submit, both. The Russian government also suggests, presumably on the basis of a misreading of this court's judgment in Georgia, Russia, that the very act of firing a missile implies an absence of control, such as to preclude jurisdiction. That proposition, we say, is self-evidently unarguable. If Russia's submission were to be accepted, it would mean that by unilaterally escalating a conflict and firing a guided surface-to-air missile capable of mass instantaneous murder at a civilian target, a contracting state would be able to switch off its Article 1 jurisdiction and thereby escape legal responsibility under the Convention. One only has to state that proposition to realise that it must immediately be rejected. The month following the attack on MH17, the Ukrainian forces temporarily recovered from the Russian Federation territory around the city of Ilovaisk. Situated on the main railway line between the Russian border and the principal city of Donetsk, the prospect of losing control of the city to Ukrainian forces presented a major threat to Russia's continued control over eastern Ukraine. On the 24th of August 2014, some 3,500 Russian forces crossed the border and advanced towards Ilovaisk, bearing in mind now that the Russian government maintains there were no Russian forces at any time on the Ukrainian side of the border. But there were, in fact, 3,500 of them who took part in the Battle of Ilovaisk in an attempt to wrest control of the territory back from its temporary seizure by the Ukrainian authorities. The invasion force, the Russian invasion force, included 400 paratroopers from the 98th Airborne Division of the Russian military. Again, the Russian government maintains that there were no Russian forces at the Battle of Ilovaisk, but the presence of Russian forces can't be seriously doubted. It's confirmed in the reports of the OHCHR and the ICC. It is evidenced in a meticulous reconstruction by forensic architecture showing the presence of Russian T-72B3 tanks in the area of Ilovaisk, and that's the reconstruction you have on the internet link in tab 2 of the additional material for the hearing. It's also confirmed by satellite images showing military vehicles and tanks returning to Russia following the battle. It is evidenced in the expert report submitted by the Ukrainian government in these proceedings detailing the presence of Russian servicemen, including from the 331st Regiment of the 98th Airborne Division, and it is evidenced by reports of Russian and international media on the deaths of Russian servicemen from the very same regiment during active service in Ilovaisk. Russia has made no attempt to answer this overwhelming body of evidence. When, on the 24th of August 2014, 10 Russian servicemen from the 331 Regiment were captured by Ukrainian military 12 kilometres from Ilovaisk, the Russian government was forced to admit their presence. However, rather than admit their involvement in the military activity, it suggested that they had simply got lost during a training manoeuvre on Russian territory and had accidentally strayed across the border. Again, there is no end to the gaslighting. The presence of Russian military forces in such significant numbers further evidences Russia's effective control over territory for the purposes of Article 1. Even if this were not the case at Ilovaisk, then persons within the physical control of the Russian military and Russian-backed paramilitary forces were, in any event, within the authority and control of the Russian Federation. Either way, Russia exercised jurisdiction during or immediately after the battle. This is the case in relation to acts of unlawful killing. It's also the case in relation to the appalling conditions of detention in which Ukrainian servicemen were detained following the Battle of Ilovaisk, and the well-documented acts of torture which were inflicted on them. There is no uncertainty as to which contracting state was responsible for these acts. They were not carried out in a context of chaos. They were carried out by the Russian Federation via its military personnel and proxies on territory controlled by the Russian Federation and against an opponent that had been defeated in battle. If Russia is not found to have jurisdiction over such egregious violations of the Convention carried out on the territory of another high contracting party, this will leave a very dangerous gap in the system of protection. Following the signature of the first Minsk Protocol in September 2014, there was a brief ceasefire. However, OSCE monitors continued to observe convoys of heavy weapons and tanks travelling from the Russian border into eastern Ukraine during the ceasefire. The ceasefire broke down, and in January and February 2015, there was a resumption in hostilities. During these months, Russian proxy forces on territory under the control of the Russian Federation repeatedly shelled heavily populated urban areas using cluster munitions and Grad missiles supplied by the Russian military. The Parliamentary Assembly at that stage condemned, quote, Russia's role in instigating and escalating these developments, including with arms supplies to insurgent forces and covert military action by Russian troops inside eastern Ukraine. It called upon the Russian authorities to, among other things, withdraw all troops, including covert forces, from Ukrainian territory and release all hostages, prisoners of war and illegally held persons. Undeterred, however, the Russian government sent yet more troops to its western frontier and onwards into Ukraine. By March 2015, the US Army Commander for Europe, Ben Hodges, estimated that there were 12,000 Russian troops supporting the separatists inside Ukraine and a further 50,000 stationed in camps along the border ready for deployment. Against the background of that massive military presence, the Russian government sought to consolidate its political control over the subordinate administrations. And in December 2014, it established the Inter-Ministerial Commission for the provision of humanitarian aid for the affected areas in the southeast regions of Donetsk and Luhansk. However, this was a complete misnomer. There is evidence that this commission had little, if anything, to do with humanitarian aid. Rather, it oversaw working groups in the fields of finance and tax law, wage policy, industry, trade and energy, electricity, transportation and infrastructure. Each working group was headed by a deputy minister from the Russian Federation and supervised by the FSB. Tellingly, not a single Ukrainian, still less any member of the separatist administrations, was represented on any of these working groups. This suggests not just influence over the political and economic affairs of the so-called DPR and LPR, but something closer to the direct rule of a colony. Members of the separatist administrations did little to hide their economic dependence and reliance on the government. In 2015, the security minister for the DPR, Alexander Khodorkovsky, estimated that 70% of the DPR's budget came directly from the Kremlin. Other estimates by international NGOs and media organisations put the figure at more like 90%, amounting to an annual spend by the Russian government in the region of $1 billion. $1 billion euros. Whatever the precise figure, this again illustrates the existential dependence of the subordinate administrations on the Russian Federation. In the words of the former head of the DPR, Alexander Zakharenko, we could not have survived without the help of the Russian people. Today, thanks to a decree issued by President Putin in 2019, residents of the so-called DPR and LPR are automatically entitled to Russian passports. What is more, the receipt of social welfare and pensions is made contingent on possession of a Russian passport. The conflict may, at least until now, be capable of having been described as frozen, but Russia continues to take measures to consolidate the de facto annexation of territory in eastern Ukraine, all the time maintaining the implausible fiction that it does no more than offer humanitarian assistance. I'm moving towards the last part of my speech now. Mr. President, in October 2016, the Parliamentary Assembly of the Council of Europe agreed a resolution which set out in clear and unambiguous terms the basis on which it considered the Russian Federation to have jurisdiction over the human rights violations in eastern Ukraine. The Parliamentary Assembly said, and I quote, "Under international law, the Russian Federation, which exercises de facto control over these territories, is responsible for the protection of their populations. Russia must therefore guarantee the human rights of all inhabitants. In the DPR and LPR, effective control is based on the crucial and well-documented role of Russian military personnel in taking over and maintaining power in these regions against the determined resistance of the legitimate Ukrainian authorities and on the complete dependence of these regions on Russia in logistical, financial and administrative matters. What was apparent and has been apparent from the outset to the Parliamentary Assembly of the Council of Europe is flatly denied by the Russian Federation in proceedings before the judicial branch of the Council of Europe. That's why I say gaslighting, because nearly everything that falls from the lips of counsel for the Russian Federation falls into that category. In these proceedings, the Russian government hasn't presented an iota of credible evidence to undermine the Parliamentary Assembly's assessment. It has obfuscated, refused to answer the court's questions, refused to give the information the court specifically requested about Russian troop deployments, just simply not answered the questions, and sought to divert attention by propagating disinformation and conspiracy theories. That's what they do. On the basis of the evidence I've touched on in this speech, and which the government of Ukraine sets out in the written submissions, it's abundantly clear that these violations are capable of falling within the jurisdiction of the Russian Federation. I'd like to say a few words about the administrative practice.
Mr. Emerson, yes. You have 3 minutes.
Very well. Well, let me take it very briefly then. The evidence shows that since April 2014 there's been a clear pattern or system of convention violations and official tolerance by the Russian government. We have set out in the various memorials and the supporting material the evidence showing repeated violations of the same or similar character, including summary executions, torture, and long-term detention in illegal detention facilities. From March 2014, the Officer of the High Commissioner for Human Rights published detailed monthly reports on the human rights situation in Ukraine. They were based on the observation of the Human Rights Monitoring Mission, a team comprising 7 full-time human rights officers and 25 national staff. Every one of these reports sets out the methodology employed by the monitoring mission and confirms that reports are provided only on the basis of information which is verified as credible and from reliable sources. And with respect to the OSCE monitoring mission, the same is true in the sense that the reports, although less systematised, contain daily analysis of the human rights violations taking place. All of that material is in the various bundles of documents, and unless there are any specific questions on specific aspects of it, those are my submissions in the first round.
Thank you very much for your submissions. I now turn to the government of the Netherlands. Ms. Hopman, you have the floor.
Mr. President, dear distinguished members of the court, today, 7 years, 6 months and 9 days have passed since the downing of flight MH17 over the east of Ukraine. The downing of flight MH17 resulted in the loss of life of 298 men, women and children. Among the victims were nationals or residents of 17 different states from all corners of the world. 196 of them were Dutch. The large number of Dutch victims has had and continues to have a profound impact on Dutch society. Almost everybody knows someone who lost a family member or a close friend. Shortly after the incident, it became apparent that the crash of MH17 had not been an incident, but that the aircraft had been shot down. Ever since, my government has committed itself to the pursuit of truth, justice and accountability for the victims of the downing of flight MH17 and their next of kin. To this date, no one has assumed responsibility. This has added and continues to add to the already tremendous grief of the next of kin. Many steps have been taken in this pursuit of truth, justice and accountability. First, investigations were carried out into the circumstances of the downing. Second, criminal proceedings against 4 suspects commenced while the criminal investigation continues. Third, legal action against Russia is being pursued. Australia and the Netherlands invoked responsibility of Russia under international law. Also, over 400 next of kin have filed individual applications to this court. With this interstate application, my government fully supports these individual applications. I stand here today on behalf of all 298 victims and their next of kin. I will not repeat the facts and observations that were already submitted to the court in my government's application and the subsequent memorials. Instead, I would like to draw your attention to a few points which we believe should be highlighted during this meeting. Before turning to the application of my government, I wish to observe the following. We have just listened to Russia's oral submissions. The pleadings of Russia, and in particular the part focusing on the downing of flight MH17, seems to be, I must say again, an attempt to cause confusion. Unfortunately, this narrative is well known to my government and illustrates Russia's conduct ever since the downing. The statement just now that the Public Prosecution Office of the Netherlands stated that the conflict in the east of Ukraine is not an international conflict is yet another example. It is simply not true. And I refer to the transcripts of the proceedings available on the internet. If the court wishes, my government can provide a copy of the statement of the Public Prosecution Office of the Netherlands. I will now turn to our application. First, I will address the core of our case, namely the role of Russia in the downing of flight MH17. Second, I will make a few remarks with respect to the evidence submitted to this court. Third, I will address the admissibility requirements of the application and the jurisdiction of Russia. Finally, a representative of the next of kin will use the opportunity to address this court. Mr. President, members of this court, my government has come to the conclusion that the downing of flight MH17 is caused by the detonation of a Buk missile launched from a Buk teller. This Buk teller was provided by Russia with a crew to the separatists. The Buk missile was launched from an area under the effective control of Russia and by, or at least with the assistance of, Russian state agents. The Buk teller was delivered by Russia to the separatists on request. It was first transported from its base in Kursk in Russia to the border with the east of Ukraine. From there, the Buk teller was transported into the east of Ukraine. Subsequently, it was brought to an agricultural field south of Snitze and west of Pervomaisky, all in the east of Ukraine, all in the so-called Donetsk People's Republic, also referred to as the DPR. This DPR was under the effective control of Russia. From the agricultural field, the Buk teller launched a missile. This missile detonated at the left-hand side of the cockpit of flight MH17. The detonation caused the front of the airplane, roughly comprising of the cockpit and the business class area, to tear off from the rear of the aircraft. As a result of this in-flight breakup, flight MH17 crashed over a large area which was under the control of the DPR. After the launch, the Buk teller was returned to Russia. These are the facts at the heart of our application. I would like to make a few remarks with respect to the evidence submitted to this court. Since the downing of flight MH17, various extensive investigations have been carried out. These investigations have led to the establishment of various facts, including those I just addressed. These facts are corroborated by compelling and convincing evidence, which has been verified and validated. The evidence presented by my government to this court focuses on various issues. These issues include the involvement of Russia in the conflict in the east of Ukraine, the identification of the Buk teller of the 53rd Anti-Aircraft Missile Brigade of the Russian Armed Forces, the location of that Buk teller on 17 July 2014, and the Russian crew of that Buk teller. The evidence submitted to this court originates from various sources. These sources include open sources, information from intelligence services, and information from the criminal investigation, such as intercepted telephone conversations, visual material, such as videos and photos, and witness statements. The government has submitted conclusive evidence to this court in support of the mentioned facts. The evidence submitted is a result of tireless efforts of various independent institutions and organizations that have committed themselves to establishing the truth. I would like to emphasize that all evidence submitted has been verified and validated. For every piece of evidence, its authenticity and evidentiary value has been examined meticulously by the competent authorities. Validated evidence has subsequently been placed in the context of other validated evidence. This allows for an assessment whether and how all single pieces of evidence relate to each other. This has painted a clear picture from the circumstances of the downing of flight MH17. According to my government, the evidence submitted satisfies the standards of this court. In any case, my governments hold that the prima facie threshold that is relevant at this stage of the proceedings is met. To this day, Russia has failed to effectively cooperate with the investigations into the downing of flight MH17. Russia has failed to put forward any convincing evidence that contradicts the facts as presented by my government. I wish to highlight that some of the evidence lies primarily within the exclusive knowledge of Russia. One striking example is the refusal to provide any information about the identified booktailer, including its location. Russia continues its narrative that the evidence used is manipulated. However, Russia has failed to submit any convincing evidence in support of these statements. Even worse, Russia has even tried to mislead investigators by submitting manipulated information. Mr. President, members of the court, our hearing today is focused on admissibility. The application and additional memorials, my government has extensively addressed the admissibility aspects of its application. Russia has replied to these submissions, but has failed to contest the admissibility with solid arguments. My government submits that the objections of Russia must therefore be rejected. I will briefly discuss the admissibility requirements in turn. I will start with the exhaustion of domestic remedies and continue with the 6-month rule. I will conclude with the issue of jurisdiction. First, the exhaustion of domestic remedies. In its written submissions, my government has made several arguments that led to the conclusion that this requirement does not render the application inadmissible. First and foremost, there were no remedies in Russia that could have been exhausted. Second, 4 special circumstances exist which entail that the obligation to exhaust domestic remedies should not be applied. I will briefly discuss these arguments in turn. First, there were no effective, adequate, and accessible domestic remedies. Given the constant and continuing denial and any action of next of kin to avail themselves of local remedies would be, to use the wording of your court, bound to fail. I wish to note that the domestic procedures that Russia referred to in its memorial only provide a remedy to hold individuals to account. These do not provide a remedy to hold the state, Russia, accountable for human rights violations. Also, while evidence demonstrates that the missile was launched by members of the Russian armed forces, it is yet unclear who exactly they are. This makes it impossible to pursue legal action against them, even if the Public Prosecution Office of Russia would be willing to cooperate. The second reason why this case there's no obligation to exhaust local remedies is that the existence of special features. There are in this case 4 special features that call for an exemption from this obligation. I will only briefly touch upon these 4 special features. The first special feature is connected to the conduct of Russia. Russia has consistently denied involvement, refused to effectively cooperate, and continuously discredited the investigations carried out and conclusions reached. The second special feature concerns the personal circumstances of the next of kin. This group is large and very diverse. There are so many nationalities, so many grades of kinship, and so many differences in wishes and desires. It is unfeasible for this group to join efforts and pursue domestic remedies in Russia under the given circumstances. The third special feature is a lack of a relevant connection between the victims and Russia. In this case, there is no consent or voluntary act that created a relevant connection between the victims of the downing of flight MH17 and Russia. In line with the draft articles of the International Law Commission on Diplomatic Protection in such a case, the domestic remedies do not need to be exhausted. The fourth and final special feature lies in the hybrid character of the application. In the past, the Court has recognized two types of international state applications, namely cases of diplomatic protection and cases involving an administrative practice. As elaborated upon in the additional memorial of last May, the present application contains aspects of both types of interstate applications. The current application covers both an isolated event, that is the downing of flight MH17 itself, as well as the subsequent element of official tolerance, namely the official policy of denial of the involvement of Russia in the downing of flight MH17. My government concludes, accordingly, that its application can be considered a hybrid application and submits that the domestic remedies rule should not be applied. This would be in line with the practice with respect to interstate applications concerning administrative practices, because of the existence of an official policy of denial. In sum, under the given circumstances of the particular case, the obligation to exhaust domestic remedies does not render the present application inadmissible. With respect to the 6-month rule, my government first holds that the violations of the procedural elements under Article 2 of the Convention and the violations of Article 3 and 13 of the Convention are ongoing. This is not contested by Russia. Russia questions, however, whether the government has complied with the 6-month rule with respect to the violation of the substantive element of Article 2 of the Convention. These objections of Russia must be dismissed. I will explain why. Invoking the responsibility of a state under international law and submitting a dispute to an international court are steps that my government does not take lightly. In our view, before taking such a step, a government must be fully convinced of its reasons to do so. This process may take considerable time. The time it may take is also dependent on the precise circumstances of the particular case. Since 17 July 2014, my government has committed itself to establishing the truth, justice and accountability. Various tracks are being pursued. The magnitude of the downing of flight MH17 and the geopolitical context in which it has taken place makes this case highly complex. This has had and continues to have a profound impact on the development and progress of the case. On 24 May 2018, the Joint Investigation Team presented its conclusions that the booktailer that caused the downing of flight MH17 belonged to the Russian armed forces. This pointed to the direct involvement of Russia in the downing of flight MH17 and several breaches of international law by Russia. Following this announcement, Australia and the Netherlands invoked the responsibility of Russia under international law. Subsequently, my government, together with Australia, first sought to negotiate a settlement with Russia. These negotiations were aimed at finding a solution that does justice to the tremendous suffering and damage caused by the downing of flight MH17. My government notes that it took considerable time for these negotiations to commence. In March 2019, it was announced that a first meeting had taken place. Unfortunately, on 15 October 2020, Russia unilaterally decided to withdraw from these negotiations. Since then, Australia and the Netherlands have called upon Russia several times to reconsider its decision. The government's decision to submit the interstate application in July 2020 was prompted by developments at this court. It became apparent that the court was moving on with the individual applications as regards the downing of flight MH17 and the interstate application of Ukraine against Russia concerning the east of Ukraine. My government considered it to be crucial that the court would have at its disposal the information related to the downing of flight MH17 obtained by my government. The primary purpose of the 6-month rule is to maintain legal certainty by ensuring that cases under the Convention are examined within a reasonable time. This is to prevent that the authorities concerned are being kept in a state of uncertainty for a long time. Mr. President, in this case, it cannot be said that Russia has been kept in any state of uncertainty. There have been particular circumstances and factors that severely delayed and continue to delay the process. It is important to take these circumstances and factors into account. One important delaying factor has been the conduct of Russia itself. My government has relentlessly and continuously undertaken all steps and efforts to establish the facts surrounding the downing of flight MH17. Our goal is to achieve justice for the victims and their next of kin. Meanwhile, my government has been confronted with the unabashed attempts of Russia to discredit the investigations carried out and to delay progress made. In addition, Russia has failed to effectively cooperate with the investigations. Not only has Russia refused to share relevant information with the authorities, it has actively attempted to hinder investigations. Ever since the downing of flight MH17, my government has continuously taken action in order to discover the truth. Since compelling evidence regarding the role of Russia in the downing of flight MH17 emerged, efforts have been made directed at finding a settlement. However, now we stand here before your court, and we submit that all circumstances regarding this case should not be ignored in the assessment of the application of the 6-month rule. Mr. President, distinguished members of the court, based on the arguments in our written submissions and as set out here today, my government is convinced our application must be declared admissible in whole. The objections of Russia must be dismissed. I will now turn to jurisdiction. The issue at hand is the extraterritorial jurisdiction by Russia over persons on board flight MH17 in relation to the substantive element of Article 2 of the Convention. At the time of the downing, the persons on board flight MH17 were within the jurisdiction of Russia. The principal reason for this conclusion is that Russia exercised effective control over the DPR area. The downing of flight MH17 took place in this area. Furthermore, the persons on board flight MH17 were within the jurisdiction of Russia through the use of force by its state agents. I will first address the exercise of effective control by Russia over the DPR area. Then I will address the exercise of jurisdiction through the use of force by Russian state agents. As of March 2014, separatists became active in the south and east of Ukraine. They were able to secure effective control, first over government buildings and by April over an area that included several large cities in the east of Ukraine. And then, in early April, separatists proclaimed the Donetsk People's Republic, the DPR. The separatists were able to secure, maintain and expand their control over the DPR area by virtue of support of Russia. Through its political, military and economic support to the separatists, Russia established effective control over the DPR area. Convincing and compelling evidence with respect to the political, military and economic involvement of Russia in the DPR area has been submitted to your court. This evidence paints a clear and irrefutable picture of the Russian involvement in the day-to-day operations of the DPR. Furthermore, the evidence clearly demonstrates that the separatists were able to maintain control over the DPR area only by virtue of the support given by Russia. Without Russia, there would be no DPR. There would be no DPR area. Russia has not submitted any convincing arguments or compelling evidence to the contrary. The jurisdictional link between the passengers and crew of flight MH17 with Russia is not only a result of the fact that Russia exercised effective control over the DPR, it is also a result from and even enhanced by our conclusion that it must have been Russian state agents who launched the missile that caused the downing of flight MH17. Intercepted telephone conversations demonstrate that separatists requested, and I quote, decent anti-aircraft defense manned with trained personnel. It needs no explanation that a booktailer qualifies as such. It follows from the evidence that after this request was made, a booktailer was brought into the east of Ukraine with a Russian crew. This Russian crew was crucial for the deployment of the booktailer and the launch of the missile. The launch of a book missile, namely, requires knowledge of the operational and technical aspects of a booktailer. The simple fact that a missile was launched indicates that the booktailer was operated by individuals trained to launch such a missile. And we know that the separatists did not have such specialists, nor did they have time to train them. According to my government, the only logical conclusion derived from all the relevant evidence is that the booktailer was deployed by members of the Russian armed forces. Thus, the missile that caused the downing of flight MH17 was launched by, or at least with the assistance of, Russian state agents. Mr. President, distinguished members of the court, on July 2014, 298 innocent individuals lost their lives. Families, loved ones, friends were torn apart. Children lost their parents, parents lost their children, and siblings lost their brothers and sisters. Ever since, my government has committed itself to establishing truth, justice and accountability for the victims of the downing of flight MH17 and their next of kin. After more than 7 years, this quest is not over, and no one has assumed responsibility. The proceedings before this court are of great importance for the next of kin and are followed with great interest, not only in the Netherlands but also internationally. My government stands here today on behalf of all victims and all next of kin. The loss of their loved ones is heartbreaking and has left deep wounds. The downing and its aftermath continue to have a deep and intense impact on their lives. The sorrow and the pain caused by the downing of flight MH17 has been further intensified by the continuous denial of Russia of its involvement. The fact that, to this day, no responsibility for the downing has been taken withholds the next of kin of finding closure. This became again abundantly clear in the addresses of many of the next of kin to the Dutch court during the recent hearings in the criminal trial. Almost all speakers explicitly referred to the fact that the conduct of Russia, its denial and its obstruction compounds to the grief that is felt. However, I'm not in a position to fully convey the impact of the downing of flight MH17 and its aftermath on the next of kin or the importance of these legal proceedings for them. Allow me to give the floor to the representative of the next of kin, Piet Ploeg. Piet Ploeg has lost his brother, his sister-in-law and his nephew in the downing of flight MH17. He is the chair of the Foundation Air Disaster MH17. Piet.
Mr. Ploeg, you have the floor.
Mr. President, distinguished members of the Court. As one of the next of kin and chairman of the MH17 Air Disaster Foundation, I am honoured to address the Court today in person, within the time allotted to me by the Dutch government. I would like to thank the Court for the opportunity granted to address the Court on behalf of the next of kin. It's important for the next of kin to be able to address the Court in person today, as stated by a next of kin, and I quote, as next of kin, it's our obligation to our beloved ones to bring this whole process to an acceptable end. In September and November last year, many next of kin used their right to deliver a victim impact statement before the District Court of The Hague. These statements expressed the impact that the downing had on their lives. They gave insight into the ordeal that the next of kin have had to undergo and are still undergoing. In the individual applications, which cover around 400 individuals, the next of kin have submitted statements regarding their individual situation. These statements demonstrate that the next of kin have suffered severely by the violent loss of their children, parents, grandchildren, brothers, sisters, uncles, aunts, cousins, and the direct and indirect consequences of their loss. The statements were moving to read and hear. Witnessing the next of kin gave their victim impact statement was heartbreaking. Unfortunately, these statements had a lot in common. We have seen and heard how families and households have been totally defeated and disrupted. How families and marriages have been torn apart. How next of kin have struggled with their employers and social relationships. How next of kin suffer from great psychological distress and physical symptoms. And how next of kin witnessed their future and their past horribly destroyed. Next of kin are suffering greatly from the violent death of their loved ones and the aftermath. They have suffered from the painful and lengthy process of repatriation, the identification of victims, and the subsequent farewell, when possible. After 7 years, they still suffer greatly from the aftermath of the downing. Mourning is disrupted, and the disaster continues. The victim impact statements made clear that many of next of kin still need psychological help. A common element in the victim impact statement is the aggravation of the suffering caused by the conduct of Russia. And this is directly attributable to Russia. Due to the Russian conduct, the legal proceedings are unnecessarily delayed. The next of kin are constantly and unwillingly confronted with news reports and disinformation. As a result, next of kin do not have the opportunity to distance themselves from what's happened. Next of kin feel powerless because they are involved in a geopolitical conflict and a war that they have no influence over. And next of kin feel that they only play a minor role in the power game of Russia. The obstruction and delaying by Russia withholds the next of kin of finding closure for the downing of flight MH17 and its aftermath. And after 7 years, there is a great need for closure. Mr. President, distinguished members of the Court, I would like to bring forward a number of quotes from the victim impact statements. These quotes gave some insight into the suffering caused by the downing of flight MH17 and its aftermath. It's of great importance for the next of kin that they can be shared here today. One next of kin stated, and I quote, "What stings me the most is that I still don't know what happened then and why. I want the truth to come out, and only when the truth comes out will I perhaps be able to move forward again." Another next of kin stated, and I quote again, "I don't think I have the ability to heal until I have some closure from knowing what's happened to the flight and who was responsible. I need to have justice." Another next of kin stated, and I quote again, "I still cannot fathom that our family is caught up in a frustrating and deadly political crisis. Politics that my parents did not choose to be a part of, yet were dealt a consequence that ended their life in an instant." Another next of kin stated, and I quote again, "I do not wish to live in a world where a passenger plane gets shot down with the death of 298 people and nothing happens. I do not wish to live in a world where those responsible just shrug their shoulders and say, 'It had nothing to do with me.' That is why this trial matters. Revealing the truth is a part of justice." Finally, Mr. President, distinguished members of the Court, research has shown that the personal suffering is compounded by what I call the disaster after the disaster. And I refer to the conduct of Russia. This is, for example, strikingly illustrated by the fact that the very day after the disaster, Russian troll factories disseminated more than 60,000 tweets in which Russia's involvement was denied and fake scenarios were introduced. The impact of spreading flagrant misinformation has added insult to injury and contributed to the grief of the next of kin. Subsequently, there was almost no cooperation with the Dutch criminal investigation into the suspects. Obstruction of the investigation took place and imputations were made against others. Russia has continuously denied their involvement, shifted its responsibilities and introduced alternative theories. This has also been raised by next of kin in individual applications against Russia before this court. The conduct of Russia is also addressed extensively by the Netherlands in its interstate application, and we fully support this. We imagine that the judges at the court regularly hear about the grief and suffering of victims whose human rights have been violated. And the case of downing of flight MH17 is no different. But what's extraordinary is that almost all next of kin have to deal with an intensified form of suffering. This is caused by the conduct of Russia, and in particular the absence of specific information from Russia on what exactly happened on the day that flight MH17 was downed in the east of Ukraine. Especially since the Russian Federation has continually demonstrated official indifference to our suffering and, by spreading misinformation, makes us feel that the bereaved do not matter. This makes it impossible for the next of kin to find closure. I wish to underline that it is of crucial importance for the next of kin that justice is served and those responsible for the downing are held to account. The criminal proceedings in the Netherlands focus on the role of 4 individuals. For the next of kin, it is of equal importance that this court rules on the role of Russia in the downing of flight MH17. And on behalf of the next of kin, I express the hope that the court will urge Russia to give full disclosure and will do everything within its power to achieve truth and justice for the victim of the downing of flight MH17 and their next of kin. During his indictment in December last year, the Dutch public prosecutor spoke the memorable words, and I quote, "A world that does not make any effort to track down the truth and punish the guilty when hundreds of innocent victims are murdered, declares its citizen outlaws." It is of great importance for the next of kin that the interstate application is considered by the court as promptly as possible and that progress continues to be made. I conclude with the final hopeful quote of a next of kin, and I quote, "I hope one day to conclude that the air disaster I hope one day to conclude the air disaster in the knowledge that justice has been done, in the knowledge that civilizations overcomes barbarism." I thank you for your attention.
Thank you very much, Mr. Ploeg, and I thank all parties for their submissions this morning. We now turn to questions raised by the judges, and first, Vice President Hjolbro.
Thank you very much, Mr. President. I do have some questions. They are addressed to the governments of the Russian Federation and Ukraine. And my questions, partly overlapping, all center around the question of extraterritorial jurisdiction. The parties have in their oral observations rightly distinguished between the two tests: effective control over an area or state agent authority and control over an individual or individuals. My first question is addressed to the Russian and the government of the Russian Federation. And Vinogrado, you are heavily relying on the court's ruling in Georgia versus Russia #2, not surprisingly. And on the basis of that ruling, you are arguing that as far as it concerns active hostilities, fighting, shelling, bombing, shootings, there is neither effective control over an area nor authority or control over individuals. At the same time, you also highlighted that that judgment concerns an international armed conflict. It concerned, as you also highlighted, the active phase of hostilities. It concerned intensive fightings and an environment of chaos. Thus, my question specifically, in the view of the Russian government, are the two cases comparable? Or, in other words, the Georgian versus Russian #2, is it comparable to the facts of the present case? If so, which phase? Is it the whole period? Is it certain periods? In other words, is it any kind of armed clashes that will follow the logic of Georgia versus Russia #2, or is it only certain intense fightings? In other words, is it also sporadic fightings during a frozen conflict? If you could please elaborate further on that. My second question is to the Ukrainian government, and Mr. Emerson, in your oral interventions you highly emphasized that there was effective control over an area at the latest at the end of April 2014. From that, I understand your logic to be and your conclusion to be that at the latest at the end of April, there is effective control over the Donetsk and Luhansk areas, therefore the victims fall within the jurisdiction of Russia. Therefore, I would understand, but I would like you to clarify that your view would be that any kind of shellings, bombings, fightings, clashes that take place after there is effective control over an area would fall within the jurisdiction, meaning that the Georgia versus Russia 2 test is no longer applicable. In other words, once there is effective control over an area, everything that a state does, including acts of war, would fall within jurisdiction. My third question is also to you, Mr. Emerson, the Ukrainian government. You elaborated in detail why it, in your view, was at the latest in the end of April 2014. Obviously, you are finding a fixing point in time because that is what the court did in Georgia versus Russia, where it was much more easy to distinguish between the active phase of hostilities and the occupation phase. But if you could maybe in shorter words try to elaborate what could be the objective fixing point. You probably noticed, as I did, that the government of Netherlands was referring to March 2014 and subsequently to early April 2014. And one could also further elaborate, say, why not May 2014, the referendum. So if you could, as briefly as possible, try to pinpoint it. A very last question, that is addressed to both parties, and it is based on assumption, assuming that we will find jurisdiction as regards active hostilities, clashes, shelling, bombings. On what legal basis, in the view of the two governments, shall the court decide the case? Are we going to apply Article 2? Or are we going to apply IHL, or are we going to apply both? And to put it just very briefly in a context, of course, Article 2 prohibits deliberate deprivation of lives and only in certain situations permit the use of force when it's absolutely necessary. Can it at all cover acts of wars and active hostilities? On the other hand, IHL clearly permits the use of force and provided that precaution and proportionality is respected. So could you please, as briefly as possible, plead, in your view, is the court to assess it on IHL only, or under Article 2 only, or under the two simultaneously, and can they, in your view, be reconciled? I apologize for the long questions.
Thank you very much. Judge Motok.
Merci beaucoup, Monsieur le Président. J'ai deux questions qui s'adressent à deux parties. Ma première question concerne le problème du rapport entre la juridiction et l'attribution, problème classique des droits de l'homme et des droits internationaux. Comment est-ce que les parties ils voient ce problème, surtout entre les lignes de notre Cour européenne des droits de l'homme et la Cour internationale de justice, et notamment dans la lumière du fameux paragraphe 115 de l'affaire Catane, qui dit que notre Cour va établir la juridiction d'une manière séparée par rapport à la question de la responsabilité dans le droit international. Donc je voulais savoir comment est-ce que vous vous rapportez à ces lignes de jurisprudence et à cette affirmation. Ma deuxième question concerne l'Ukraine, mais aussi la Russie. Et il s'agit de l'incident concernant l'enlèvement des enfants. Et bon, on sait bien de votre mémoire qu'il y avait 13 incidents regardant l'enlèvement des enfants. Mais ma question est la suivante. Le problème, comment est-ce que vous pouvez nous indiquer quel est le seuil depuis cette pratique puisse être interprétée par notre Cour comme une pratique administrative. Merci beaucoup.
Merci. Juste Pastor Villanova.
Merci beaucoup, Monsieur le Président. J'ai deux questions donc à adresser aux représentants de la Fédération de Russie et qui intéressent la destruction de l'avion MH17 Même si ces deux questions donc intéressent cette question, rien n'empêche les deux autres parties d'en discuter si le cas échéant. En ce qui concerne la première question, elle est formulée de la façon suivante. Est-ce que le gouvernement néerlandais avait la possibilité de déposer en Russie une plainte pénale avec constitution de partie civile contre les auteurs présumés de la destruction de l'avion? Et si tel était le cas, devait-il obligatoirement identifier les éventuels responsables ou bien une plainte contre X suffisait? La deuxième question est la suivante. Est-ce que selon le droit processuel russe, le gouvernement néerlandais avait qualité à agir pour le compte des familles des victimes? Dit autrement, est-ce que le droit processuel russe exige que la plainte, avec constitution de partie civile, soit présentée exclusivement par la victime ou par son représentant légal? Je vous prie, en tout état de cause, de citer les articles légaux pertinents. Je vous remercie.
Merci. Vice President O'Leary.
Thank you very much, Mr. President. My colleagues have asked questions about jurisdiction. I will go to different issues. My first question is for the Russian government, but the other parties are welcome to respond. The Russian government alleges that the complaint under the substantive limb of Article 2 in the case relating to MH17 is out of time, and that the Dutch submission that the alleged violation of Article 2 is a continuing one erroneously conflates the procedural and substantive violations alleged. However, my question is that given that the investigations into the downing of MH17 continue to this day to produce new and relevant evidence, on what basis in the court's case law could and should the court split the procedural and substantive limbs of the Article 2 complaint in the very specific circumstances of a case such as this? My second question is directed principally to the Ukrainian government. The other parties are free to respond also. Mr. Emerson, in his submissions, rightly points out that at the admissibility stage in an interstate case, the court does not proceed on a manifestly ill-founded basis. He sets the standard in an interstate case as, I quote, the need to establish a genuine allegation made in good faith which meets the technical requirements regarding jurisdiction. However, in paragraph 263 of the Crimea decision, the court clearly established the applicable standard of proof in these cases as the establishment of sufficiently substantiated prima facie evidence. So applying that standard, could I ask the Ukrainian government to respond to the Russian government's claim that they have not discharged their burden of proof regarding the complaints relating to Articles 4, 9 and 11. And I should emphasise that you don't need to be detailed in your oral response, but you could direct us specifically to the relevant paragraphs of your written submissions. But I would ask you orally to specify the scope and nature of your Article 9 complaint in response to the arguments of the Russian government. Thank you very much.
Thank you. Judge Utkiewska.
Thank you, President. I have two questions. My first question goes to all three governments, and it's a kind of specification of Judge Kyorbo's question. Now, viewing the case at hand through the prism of judgment Georgia versus Russia 2, and Russian government heavily relied on it, the court found that the events occurred during active phase of the hostilities, did not fall within the jurisdiction of Russian Federation. So again, through prism of that, I would ask all governments to clarify from the beginning to end exactly which period or periods, if any, if you find any, from the moment the conflict in eastern Ukraine started in April 2014 and during the whole period under consideration. So which exact periods do you consider can be defined as active military hostilities? And my second question, it's actually a follow-up question to the government of the Russian Federation, but other governments can comment as well. In your observations, you quoted on several occasions the court's conclusion in paragraph 1 to 6 of Georgia versus Russia that in the event of military operation, armed attacks, bombing or shelling, there is no control and thus no jurisdiction. Now, the Ukrainian government in their observations and also this morning referred also to the pattern of summary executions and killing of civilians and persons hors de combat and so on. In your view, does the conclusion in Georgia versus Russia to which you referred cover the allegations of this pattern as well and also other alleged substantive violations of the Convention? Thank you.
Thank you. Judge Wojciech.
Thank you, Mr. President. I have two questions, both concerning the MH17 disaster. The first one is addressed at the government of the Russian Federation. I would like to know whether there has been any administrative or any other type, maybe military inquiry into the events, and are there any official reports available to the Russian authorities able to rebut the version of events presented by both applicant governments on this disaster. So have there been any types of official inquiries undertaken in Russia? My second question is addressed at all three governments. It concerns the issue of possible remedies and a potential investigation or inquiry in the region of Donetsk. Has there been there any kind of inquiry or investigation for the purpose of establishing what happened, how the events involved in the connection with the MH17 disaster? So any inquiry at the local level in the Donetsk region? Thank you very much.
Thank you. Judge Grodzev.
Thank you, Mr. President. My question is a bit of a follow-up of the question of Judge Wojciech, and it is also to the government of the Russian Federation in relation to their views on a possible investigation of the downing of the MH17 flight. In the views of the government of the Russian Federation, is there any evidence providing a basis in accordance with domestic law for the opening of an investigation within the Russian Federation? And if the answer is yes, what would be that evidence and what would be the legal basis under domestic law to open such an investigation?
Thank you very much. Judge Huseynov.
Thank you, Mr. President. I have two questions, but I'm afraid I will have to repeat to some extent the questions raised by my distinguished colleagues. My first question is very much linked to the question that my colleague Judge Kolber has asked, relating to the effective control allegedly established in the area in question, in the territories in question. Mr. Emerson, in your intervention today, you submitted that you tend, that was my understanding at least, you tend to accept our court's finding in Georgia or Russia that during active military hostilities, armed attacks, bombings or shellings, in such cases there can be no effective control over the area. But before that, you submitted that overall control over the area had been established as from April 2014. But talking about the case Georgia over Russia, you said that if not effective control during active military hostilities, according to the Georgia over Russia, but there was nevertheless the second limb of state jurisdiction. That's to say, state agent authoritarian control. So I think I need clarification on this aspect. What you say about the second limb, is it compatible with your statement that you agree that you said about state effective control, which is the first limb, since April 2014? So this is my first question. And my second question is addressed to the representative of Russian Federation, and again is very much linked to what Judge Grozov has asked concerning the procedural obligation to carry out an effective investigation into the downing of MH17. I would like to know what specific procedural steps have been taken by the relevant Russian authorities into that incident. You said that no request had been submitted to launch a criminal investigation into the case. Does it mean that a request or a complaint or an allegation is the only legal ground, according to Russian procedural law, to initiate a criminal investigation? Are there other grounds in the Russian procedural law for an ex officio initiation of criminal proceedings? Thank you.
Thank you very much. Judge Lobov.
Thank you very much, Mr. President. I have two questions. First would be addressed to the government of the Russian Federation, and it is a follow-up of previous questions on the domestic remedies available at the national level. Colleagues have asked already about steps which were taken so far, so my question would be about possible legal means that may still be used in the Russian Federation to contribute to elucidating the circumstances of the MH17 tragedy. And the second question would be addressed to the applicant's governments, but more particularly to the government of the Netherlands. You mentioned repeated requests for legal assistance you have made to the Russian Federation. So you mentioned this in your written memorial in relation to the MH17 downing. And I would like you to inform the court more specifically about the results of these requests. And the second part of the question may be addressed to both governments, but again, first of all to the Netherlands, what further means of international legal cooperation do you see available at the present stage and for the future to elucidate the circumstances of the tragedy? Because you referred to international cooperation avenues several times in your submissions today. So what further means do you think are available? Thank you.
Thank you very much indeed. I do not see other questions wanting to be raised. We will then break, in light of the number of questions, until 25 minutes past noon, so 12:25, 35 minutes. The hearing is suspended.
La Cour.
Please take your seats. The hearing is resumed, and I call Mr. Vinogradov.
Thank you, Mr. President. I would like to thank the judges for the questions. They absolutely cover the issues we have highlighted this morning, and I will turn first to the questions, and then, if I have some still time, I will address certain points of the presentations of the government of Ukraine and the government of the Netherlands. As to questions of judges Hilbro and Yutkivska as to Georgia to concept applicability in the present case, the period it should be applicable. The Russian Federation believe that the entire period, as set in the applications of Ukraine, and which is more limited, notably the application of the Netherlands, is within application of the Georgia to concept of war hostilities. That means that provisions of the convention, at least material, are not applicable to the active phase of war. And I would like to draw attention of the esteemed judges that both parties, both Russia and Ukraine, submitted numerous maps of evolution of the frontier throughout the period, which clearly shows that it was an active stage throughout the period. Next question of Judge Kulber as to applicability of Article 2 of the Convention, or alternatively or supplementary of international humanitarian law. We believe that provisions of international humanitarian law could not be applied in separation and isolation from the provisions of the Convention still. But it was within my presentation of this morning that we believe that Article 2 is not applicable to the facts as set in the applications of Ukraine and the Netherlands. Then question of Judge Yutkivska as to applicability of the concept as mentioned in Georgia 2 case to civilians and in respect of other provisions of the Convention and protocols to it. It is our submission and position that definitely it is the case that the provisions of the Convention are not applicable as to civilians as well, and to not only to Article 2, but other provisions of the Convention. This is not only our position, but I would like to recall this is the position of the Court itself. We know that hundreds of individual applications lodged on the events in South Ossetia in 2008 were declared inadmissible on this criteria. Now I turn to the question of Judge Motok as to the administrative practice where transfer of children across the border. Our position that 3 isolated cases cannot be considered and treated as substantiation of administrative practice. And for this reason and for the reasons said by me this morning, we believe that this application of Ukraine should be declared inadmissible in entirety. Now I turn to the question of Judge Pastor Villanova, re-initiation of criminal cases, both questions. First, I would like to inform the court that the Netherlands had and still have a possibility to launch a criminal investigation in Russia. It is stipulated by international treaties, multilateral and bilateral, between the Russian Federation and the Netherlands, and it is in the hands of the Netherlands to submit the request for initiation a criminal prosecution in the Russian Federation. Moreover, as I stated this morning, Russia already invited the Netherlands to do this step, but our Dutch colleagues preferred not to follow this invitation. What is important, transfer of case file, or at least a piece of it, to Russia does not prevent the Netherlands to go further with their own domestic investigation and trial. It is not for us, and it is still open for the Netherlands to do the step. Then, as to the possibility of victims to launch criminal investigation in Russia, I would like to recall, with not no reason, but still it is a matter of fact, that none of individual application to initiate criminal investigation in Russia was launched by them. And turning to the question, my answer is yes, it is in the hands of the authorities of the Netherlands to forward these requests through the channels of mutual legal assistance. And I would like to inform you that this was not done, ever. Now, question of Judge Muro-Wikström as to the requirement of non-exhaustion of...
Mr. Vinogradov, Judge Muro-Wikström did not ask a question.
Wait, so, I'm sorry.
You're referring to whom you think? Well, go ahead. We will go ahead with answering. We will find out.
I'm sorry for the confusion. So, as to the requirement to follow the 6-month rule in interstate applications, yes, it is still the established case law of the court, and once again, it is a judgment of the Grand Chamber of Georgia versus Russia too. As to the question of Judge Wojtyciak, as to any investigations and inquiries which were done in Russia, according to the received MLA request from the Netherlands, we have done a good number of inquiries and investigative measures, and those were done on the Russian territory and within the Russian bodies. And those materials were transferred to the Dutch authorities, to the Ministry of Justice of the Netherlands. And as to the issue whether the Russian authorities took those measures in Donbass and in Donetsk, no, surely not. This is the territory of another sovereign state, namely Ukraine. So clearly we cannot, and we did not. Then, as to the question of Judge Grozev, as to possibility to initiate a criminal investigation in Russia according to the Russian law. According to the Russian law, it is possible to initiate criminal investigation when it was committed on the territory of the Russian Federation, when it was committed by Russian nationals or against Russian nationals. And till the moment when the joint investigative team revealed that some Russian persons were accused, there was no specific ground for Russia to initiate criminal investigation. But just after this information was made public, the Russian Federation requested the authorities of the Netherlands to transfer the materials or pieces of case file in respect of those 3 persons accused in the Netherlands. I mean 3 Russian nationals. But once again, I recall that this request was refused, and we are still open to follow this road if the authorities of the Netherlands do the appropriate step. I feel that in many respects I have answered the question of esteemed Judge Gusseinov. It is not the only way to initiate a criminal case by the means of application of the victims. So once again, this is possible for the authorities of the Netherlands to submit the request for initiation of the criminal investigation in Russia. It is an opportunity for the victims or their representatives to do this directly applying to the Russian investigative authorities, which I draw your attention was never done. And then finally, questions of Judge Lobov. I confirm that still there exist domestic remedies in Russia for investigation. However, this should be launched by someone according to the Russian Federation, and those are the relevant authorities of the Netherlands and the victims. I would like to comment on several points highlighted by my esteemed colleagues from the Netherlands and Ukraine. First, I regret, but I cannot agree with my colleague, agent of the government of the Netherlands. It was specifically stated by the prosecution on the 20th of December last year that the prosecution of the 3 persons in the District Court of The Hague could not be effectuated if it is an international conflict, and those are representatives of the Russian authorities or agents thereof. It was specifically stated, and I can name, and I'm willing to provide the court with the extract of that day. Then we were really surprised to hear the very inventive artificial concept of exhaustion of domestic remedies as presented by the government of the Netherlands. It is unclear for us why the statement that Russia does not cooperate in investigation is a requirement for which non-exhaustion is not necessary. And I would like to inform the esteemed judges that the position of our colleagues from the Netherlands changed throughout the times. Namely, in 2016, in the correspondence between the competent authorities of the Russian Federation and the Netherlands, our Dutch colleagues informed us that they are delighted with the course of investigation, that the MLA requests are executed, And nothing was wrong in this part. And I wonder from which time the situation changed, and I recall that the shutdown took place in 2014. It was long before the time. This is first. Then, still, we cannot understand the reason why individuals cannot apply to Russian investigative authorities. We believe that this is not the reason that there are many of them and they are in different countries. I would like to assure you that a single application is enough. They should not be accumulated in an application lodged on behalf of all of them. And finally, we cannot understand how a single piece of event, namely the crash of the airplane, could be considered as an administrative practice. We truly believe that the Netherlands failed to exhaust domestic remedies. Then, we cannot understand the argument that the 6-month period could be, in some respects, irrelevant, because for the governments it takes more time to take this very strategic decision. It is true that it is relevant for all the states. Interstate application is a political step as well. This is true. But we cannot find a single evidence that it might be the case in the convention. So we believe that this assertion is absolutely irrelevant. Then, turning to the issue of negotiations between the Russian Federation, the Netherlands, and Australia, we understand that there might be some concerns of the government of the Netherlands in this respect, but the events were misrepresented by my esteemed colleague. First, interstate application of the Netherlands against the Russian Federation was lodged, and only several months later, those negotiations were closed. Then I would like to turn to the submission of Mr. Plug. And this is our address to the court, but to the victims as well. I would like to assure you that we are also interested in finding the truth. No investigation is concluded by the moment. No trial is concluded in any state. We know that Russia bears no responsibility in this respect. This is what we know. We also know that it was the airspace of the Ukraine which was managed by the Ukrainian authorities. What we know is that it was established by the experts of the District Court of The Hague. That launch was done from the territory under control of the Ukrainian armed forces. And we also know, and it is a matter of fact, that the missile, as presented by the joint investigation team, is the Ukrainian one. We understand that the victims, they clearly want the truth, and we are willing to assist them. And on behalf of the Russian Federation, I would like to declare that we will make available every piece of document transferred to the Dutch authorities on the MLA requests. And we are well prepared to go further. We will make them publicly available. And everybody can see what is true and what is not. Finally, I will turn to some points of the presentation of the Ukrainian authorities. First, I am pleased to hear that the Ukrainian authorities admitted that most of the facts as presented by them are not substantiated. And although the test of manifestly ill-founded is applicable specifically for individual applications, we truly believe that every allegation presented within the interstate application should be substantiated with evidence. And it is not the case for the applications of Ukraine. Then it was a presentation by the Ukrainian government of the situation. It was very hard to understand. Is it the description of the case pending before the court, or the general picture? I invite the judges to pay attention to the facts specifically within the time limit as described in the applications. And turning to this period, we heard few or nothing about evidence supporting the position of the government of Ukraine. And another point to finalize, we are also well prepared to make publicly available the content of the humanitarian assistance provided by the Russian Federation to the people of Donbass. And everybody will see what is it. To conclude, I invite the court once again to declare all the three applications inadmissible. Thank you.
Thank you, Mr. Vinogradov, for your submissions. Mr. Emerson, you have the floor.
May I begin by dealing with rather complex series of questions posed by Judge Vice President Kilbro. First, the first part of the question was addressed to Russia, was whether or not the facts of the present case are comparable to those at issue in Georgia. And I'll just touch on that briefly as I go through all of the questions. The second question asked whether or not Ukraine's position was that once it was clear that Russia was in effective control of a portion of the territory, then any skirmishes or conflicts, bombings or shellings would fall within that jurisdiction. Thirdly, I was asked to choose a particular date as precisely as possible for if you like, the start of the period during which Russia was in effective control of territory. Can I answer this in a compendious way? And I hope that it will address all of those questions. First of all, I'd like to reiterate the distinction that we seek to draw between the first limb of the court's Georgia test of chaos, if you like, I'll call it the chaos test, of active hostilities where it's not possible to determine which party is in fact in effective control of the territory, and the second limb of the test, which is effective control by state agents over the victim. And I think I've made the point earlier on that whilst the former makes logical sense, that if the court can't apply its legal tests because the circumstances are so confusing it's not possible to determine who is in overall control, then that's a reason in itself for forbearing to pass judgment on a question that can't be satisfactorily answered. The same does not apply to the second limb of the Georgia test, namely where somebody is captured in a situation of hot conflict and is therefore under the control of the forces of the opposing party, but entirely at their mercy. In those circumstances, we would submit that it needs a far more compelling justification to exclude them from the extraterritoriality principle than is given in the Georgia judgment. We're inviting this court to revisit the second limb of the Georgia-Russia test and to say it's not sufficiently connected to the rationale underlying the first limb. And so the positions are not inconsistent, because the essence of the first limb, the essence of the Georgia-Russia new principle, is one of evidential analysis. Is it a case where there is such a degree of confusion on the ground as a result of active hostilities that the court can't determine where effective control has been established? And if that's the test, and that's the rationale for the test, then obviously it's capable of being applied to a range of different situations. But equally, it's only going to be applicable where the consequence of the active hostilities is to make it impossible or extremely difficult to determine whether the territory in which the violations occurred was under the effective control of the opposing party. That's the essence of the reasoning. So with that in mind, if I could ask those of you who have the bundle of exhibits with you on the desk, that was filed in November and I think should be on your desk, you will see that the first, Annex 1, is a bundle of maps. And the reason this is relevant is I hope it will illustrate the point that I'm trying to make. If you look at the map, the very first map is dated 20th of May. What we will see as you look through these maps is that there's a core of Donetsk, Luhansk that remains always under the control of the separatists, and therefore we say under the control of the Russian Federation. But there are also a diaspora or penumbra of areas which change hands at various different times. So no one can question the position of Donetsk, because it is at all times under separatist control, whereas there are changes in the boundaries in other places. So if you look at this first map, you can see the darker pink area, which is, if you look at the key, territory under the control of the occupation forces. And then you can see beside it a sort of lighter coloured hatched area, which is described as territory under the conditional control of the occupational forces, which tells you that on or about the 20th of May, the areas that Ukraine was targeting to retake are the areas in the lighter hatched colour, whereas what was conceded by then was that the area in the pink was beyond Ukraine's control and could no longer be regarded as a place over which Ukraine could retain control. And if you flick through, you'll see the boundaries vary, but there's always a core that remains under the complete and effective control of the rebels. So if one is looking for a rational way to apply the Georgia-Russia test to the very different facts of this case, then the way to do it, it seems to me, is to look at whether, with a particular violation or series of violations, whether they occurred in territory that was unequivocally under separatist control. Now, I'm going to be cautious in how I word what I'm about to say, but Mr. Vinogradov has just said three things to you about the shooting down of MH17, which in this context are relevant. He said, we know as a fact that Russia bears no responsibility. He said, we know that it was shot from Ukrainian-held territory. And he said, we know it was a Ukrainian missile. Those submissions are all untrue. If you look through the map, you'll get through to the July date. You'll see the plane crash isn't shown in the first few maps because it had never happened by then. But if you look at the fourth map, which is the 21st of July, you will see the location of the air crash right slap bang in the middle of the area of exclusive separatist control. We also know, because you've got it in the evidence, that there is a completely incontestable line of continuity between the 53rd Division, where the book teller came from, watching it through traffic cameras and other methods, travel up to the border, across the border, and down to Snizhny, which is where that picture shows it to be, where it was operated by somebody qualified to operate it, was shot into the air, and then the plane obviously came down, and then the vehicle that brought the book teller system in is traced back again to the border and over back to the 53rd Division. The evidence is completely incontestable that Russia sent that missile and fired it. Not the separatists, Russia. They didn't have access to that material without Russia. So why does counsel for Russia, or the agent for Russia, stand up in front of this court and tell you that we know as a fact Russia had no responsibility, that it was shot from an area under Ukrainian government control, and that it was a Ukrainian missile? Those are lies, and they're not mistakes, they're lies. And the Russian government knows they're lies because they sent the missile. So the question is, you know, it's easy enough if you have an opponent who's prepared to descend to those levels to start saying it's all too confusing, it's a situation of chaos. It's not chaos. This is an attack on this institution. It's an attack on democratic institutions. It's daring you to disbelieve. It's typical and classic of Russian international strategy. It's lying in your face, knowing you know it's a lie, and seeing how much pressure that puts on this central constitutional court of the entire Council of Europe. You've got to ask yourself why. Now, to come back to the question at issue, and I need to move on to the other questions, to come back to the question at issue, we have chosen the end of April because the process by which Russia bussed in the military personnel from Crimea and set about fomenting this phony rebellion so that it could annex the territory, which has clearly been the long-term goal, that process was cumulative in the sense that there were particular riots, attacks on particular buildings, taking control of town halls and so forth. Two key dates are the 14th of April, where the Russian agents leading the separatist mob took control of Slavyansk and two other major cities, and the 30th of April, when the acting President of Ukraine, Mr. Turchinov, admitted that the government had now lost control of these territories in eastern Ukraine and that Ukrainian forces would be unable to take them back. So that was the 30th of April. The government of Ukraine admitting that they'd lost these areas and would not be able to retake them. So that's a pretty good watermark for saying that's when Russia had consolidated its effective control to the extent that the state with sovereignty over the region had effectively abandoned any realistic chance of retaking it by force. And if you look then at the map, the first map in that bundle, that's 3 weeks later on the 20th of May, and you can see very clearly this is the area that was beyond being retaken, and these are the areas that Ukraine hoped it might retake. But the fact that there may be two different categories applying the Georgia-Russia test does not mean that in that category where overall control is unequivocal, which includes not only Donetsk but also Snizhny, where the MH17 rocket was fired from, that remains the same. And there's no point in asking what was the situation in a different point of time. You need to look at the maps at the relevant time. You need to look through the violations. Most of them post-date that period. Most of the violations are not alleged, are concerned with the period beyond the 30th of April. But fundamentally, through to the end of the year, there were fluctuations around the edges where the Ukrainian forces moved in to try to take back certain areas, and they did briefly take back a crucial area in the vicinity of Ilovaisk, and that's when the Russian forces crossed the border in such huge numbers, 3,500 of them, to push the Ukrainian forces out of Ilovaisk. Now, we could debate here today whether or not the Russian attack on Ilovaisk to try and dislodge the Ukrainians falls within or outside the test in Georgia, Russia. But in the end, you don't really need to decide that, because in Ilovaisk there's no direct complaint about the conflict itself. The complaint centres primarily on the atrocious pattern of treatment of 300 Ukrainian service personnel who were taken into custody as prisoners of war and very severely tortured over a period of weeks, as well as being the subject of a dishonourable attack as they were retreating, in other words, a false flag attack. So that's the general answer that I'm going to give to all of the questions that touch upon overall control. Georgia is very different because the territory in issue in Georgia was clearly Georgian and under Georgian control until Russia invaded, and after 3 days or 4 days the Georgian troops withdrew, and from that point onwards it was under the effective control of Russia. And that's when the ethnic cleansing happened. Houses were burnt, people were killed in large numbers and tortured and so forth. And it's the same story here. It's just that here we're dealing with things the other way around. I mean, this is territory that Ukraine, for example, was seeking to retake in the Battle of Ilovaisk. There are differences of various different kinds, but the test that you need to apply is going to be a purposive one. Are the facts so confusing that it's not possible to tell who was in effective control? Well, it's a counsel of despair to say that because there are peripheral changes in the border, it follows that Russia should be allowed to avoid accountability for the grave crimes it's committed. So that's the general answer to the questions about effective control. It's perfectly clear there was a core of area of effective control where all the worst violations occurred, and it remained fundamentally under the separatist control from, at the latest, the end of April, right the way through to today. And in fact, from the beginning of 2015, there are very, very few changes to the borderline either. Right, so the other aspect of Judge Kjellbro's question was, if you're looking at Article 2, and that would include Article 3 in that, is the correct test international humanitarian law or the Convention test under Article 2, or both? And the short answer to that is that it is the Court's approach, and indeed the approach of the ICJ, has been to say that human rights treaties continue to apply during a situation of armed conflict, but that they are to be interpreted and given effect in a manner that is consistent with the rules of humanitarian law. And so, as Judge Kjellbro pointed out, there's a fundamental difference between killing, which is permitted by IHL in a combat situation, and the test under Article 2. And in those circumstances, viewing Article 2 through the prism of IHL, we accept you need to establish an IHL violation, in effect, in order to be able to show that the killing was arbitrary. And I think that's the way in Article 2 it works. The killing will be arbitrary for the purposes of Article 2 if it's a violation of humanitarian law, because humanitarian law is the lex specialis dealing with the situation, but human rights law continues to apply. And although this has been the subject of endless treaties by PhD students over the years, in fact, in practical terms, it's not as difficult as it sounds to apply. Certainly Article 2 is straightforward, Article 3 is straightforward. There are some difficult questions around detention, Article 5. But in this case, we're dealing with not simple detention, but detention and torture for the most part. So that would clearly constitute a violation of Article 3 and would be similarly a violation of humanitarian law. Judge Motoc, jurisdiction and attribution. This is, I think, a reference, well, it is a reference to the test adopted by the ICJ in the Bosnia genocide judgment and the test adopted by the International Law Commission for attribution on the one hand, and on the other hand, the test consistently adopted by this court for Article 1 jurisdiction. Russia has been trying to get this court to change its case law in every single case that it's been involved with for the past 5 or 10 years. The same submission is made, it's always been rejected. It was rejected in Katan, it was rejected in Georgia, it was rejected in Crimea as a test for jurisdiction. And as is recognised by Mr. Vinogradov, the only way Russia can avoid Article 1 jurisdiction in this case is to persuade the court to adopt a different legal test, to overturn its own consistent jurisprudence. And it's not as though this point has just been raised for the first time. Russia's been raising it over and over again every time it gets knocked back. So, yes, when it comes to attribution, we obviously look at the appropriate tests for determining whether Russia is responsible for the actions of its own service and intelligence personnel, but also for the acts of a subordinate local administration. And that is a test under the Convention is qualitatively different from the test that the ICJ applied in the genocide case. But certainly for the purposes of Article 1 jurisdiction, this court's case law is consistent, and Russia's repeated attempts to persuade the court to take a different approach are as futile in this case as in the previous cases. And
Mr. Emerson, you have 2 more minutes, please.
Really, yes. Well, I'm working my way through the questions. The children abductions, we say that can be treated both as part of a pattern and therefore administrative practice, and approached as a parens patriae on behalf of the victims. The question of Judge Villanova addressed to the Netherlands. A number of questions have been addressed on the MH17 issue of the 6-month time limit and exhaustion of domestic remedies. I would just like to add a perspective on those questions and answers, because MH17 was very firmly a part of Ukraine's case before the Netherlands lodged their application. Ukraine's case on MH17 was lodged well within time. It was lodged in November 2014. And it was pleaded, and is still pleaded, as part of an administrative practice alleviating the victims from any responsibility to exhaust domestic remedies. So whatever technical points may be taken or argued in the context of the Netherlands application, in fact, they are all moot points, because those arguments do not apply to the very same allegation as it is pleaded by Ukraine in its application. As far as the Judge O'Leary's question is concerned, we were asked about whether or not the violations of Articles 4, 9 and 11 were sufficiently substantiated on the evidence. Can I just give you the references very quickly? Article 4, you'll find that in the witness statements and summaries at paragraphs 999 to 1000 of the 16th of October 2007 submissions. Article 9, religion. I mean, the suggestion here that there is insufficient evidence, I'm afraid, rather beggars belief. Again, same submission, 16th of October, summary at paragraphs 1001 to 1002. The submission is that Ukraine's Orthodox Christians became a target for reprisals. Amongst the material there are statements from an Orthodox community in Donetsk who were all victims of torture because they were targeted as Orthodox Ukrainian Christians, as well as a statement from Mr. Didrik, who was the Orthodox priest in the area, and who was, together with his parishioners, personally persecuted by Igor Girkin. So, with respect, there's plenty of evidence in that regard. Articles 10 and 11, there are a series of allegations properly particularised of assaults on journalists, facts regarding kidnapping, disappearance and torture of Ukrainian activists and journalists, and you'll find the materials summarised at paragraphs 103 to 108. Yeah. So the answer, as I understand it, to the question whether there was any investigation of MH17 by the Donetsk authorities, and this was Judge Wojciech's, I thought Judge Wojciech's question, is no. Judge Husseinov, I hope I've addressed your question in my answer to the first series of questions, which is effectively we say that the two limbs of the Georgia-Russia test, one is logical, the other is illogical. The second limb has no basis in the rationale for the first limb. And we say you should either abandon that, at least as regards prisoners of war, just in the same way as in Georgia and Russia, somebody was killed in Article 2 violatory circumstances during the conflict, the hot conflict, but still the failure to investigate their death, the death itself falls outside Article 1 jurisdiction, but the failure of the Russian authorities to investigate the death after the end of the hot conflict was a violation of the procedural obligation in Article 2. It's exactly the same. How and why should any of the arguments used by the court in Georgia-Russia exclude a situation where people are taken prisoners of war and then tortured? And if there's no good answer to that, that test is inadequate, or certainly inadequately explained in the Georgia-Russia judgment, the second part of it. The first part, as I say, we say results in a different conclusion in this case. I don't know if I've covered everything, but I think Judge Lobov's question, I think, isn't really addressed to Ukraine, more to the Netherlands, but I've answered it in relation to the Donetsk investigation, and I think that is all.
Thank you very much, Mr. Emerson. I now turn to the government of the Netherlands. Madam Koopman, please.
Thank you, Mr. President. I will reply to some questions posed, and then will give the floor to my colleague, Ms. Renée Lefebvre. In reply to the question posed by Judge Dubinska, I wish to reply the following. In Georgia versus Russia 2, the government distinguished between events during an active phase of hostilities and during a period following that phase. The court considered that between 8 and 12 August 2008, there was an armed confrontation and fighting between enemy military forces seeking to establish control over an area in a context of chaos. That was a quote. According to the court, under these specific circumstances, Russia did not exercise effective control over the area during that said period. The situation in east of Ukraine at the time of the downing of flight MH17, as explained before, is fundamentally different from the situation in Georgia between 8 and 12 August 2008. Unlike the situation in Georgia, in the east of Ukraine, independent republics were declared that survived by virtue of the support of Russia. The efforts of the separatists to take over vast areas in the east of Ukraine, supported by Russia, led to the establishment of a new status quo. By April 2014, separatists controlled the DPR area. This status quo consisted of Russian control through the separatists over the area of the DPR. It is important to note that armed clashes continued to take place. These did not, however, affect the established control. Therefore, there was no active phase of hostilities in the sense of an armed confrontation between enemy military forces seeking to establish control over an area in this context of chaos. Russia already had established such control over the area and was able to maintain this control. It follows from the court's established case law, as cited in our written submissions, that armed clashes do not render it impossible to establish or maintain control. The Convention is applied to the use of military force, both territorially as well as extraterritorially. The present case is and should be no exception to this. Any other appraisal of the applicability of the Convention would seriously compromise its purpose and its effectiveness. If the existence of jurisdiction is dependent on whether hostilities in an area die down or flare up again, this may lead to situations in which there would be jurisdiction one day, but not the next, only to present again the following day. The protection offered by the Convention could then be switched on and off at the initiative of one or more states engaging in these hostilities. With respect to the question of Judge Lobov, with respect to the request of mutual legal assistance, I would want to mention the following. As set out in the application of 10 July 2020, it is our position that Russia did not effectively cooperate with the criminal investigations. This is an important distinction. It is not argued that Russia has done nothing at all. However, several requests for mutual legal assistance have remained unanswered. The response to other requests have been incomplete or only responses to parts of the request. For the reasons set out in its application, my government submits that Russia has not adequately responded to the requests for mutual assistance. This is extensively elaborated upon in Chapter 4.3 of the Statement of Facts, which is an Annex 1 to our application submitted in July 2020. Furthermore, to be complete, I wish to make it clear that all information collected in the course of the criminal investigation, including all material that has been provided by Russia, has been thoroughly examined by the appropriate means and methods. The fact that the JIT, or the Public Prosecution Service of the Netherlands, did not reach the same conclusions on the basis of the information as Russia did, does not mean that the information shared has been ignored. With respect to the second question of Judge Lobov, my government's aim is to find a solution that does justice to the tremendous suffering and damage caused by the downing of flight MH17. We are open to any modalities that may bring us closer to such a solution. Therefore, I would like to reiterate our call on Russia to return to the trilateral negotiations. I will give now the floor to Mr. Lefebvre to answer the remaining questions.
Please, sir, you have the floor.
Thank you, Mr. President. Mr. President, distinguished members of the Court, I will first address questions of Judge O'Leary and Wojciech, and then, with your permission, would like to make a few comments on Russia's observations today. With respect to the question of Judge O'Leary on the continuing criminal investigation and proceedings in relation to the procedural and substantive elements of Article 2 of the Convention, my government would like to stress that the criminal investigation and the government's investigation into the potential involvement of a state in the downing of flight MH17 are carried out separately. The criminal proceedings and investigation also focus on the role of individuals rather than the role of a state. And that's on the basis of the independent criminal investigation of the Dutch public prosecutor. According to my government, there is convincing and compelling evidence regarding the involvement of the Russian state in the downing of flight MH17, amounting to violations of the substantive as well as the procedural limb of Article 2 of the Convention. And these proceedings against Russia here today are separate from the criminal proceedings against individuals and can, in my government's view, proceed pending those criminal investigations and proceedings. With respect to the question of Judge Wojciech and on investigations in the DPR, I can say that a technical investigation into the causes of the downing of flight MH17 was carried out by the Dutch Safety Board, including the gathering of evidence for the purposes of investigations. And for this purpose, arrangements were made with the local entities in the DPR. With respect to the Russian statements made here today, I will limit myself, for the sake of time, to one of the issues that was raised. According to Russia, the Netherlands is misleading the court because Russia was in fact willing to take over the criminal proceedings against 3 Russian suspects, but the Netherlands didn't let them. My government firmly rejects the suggestion that it is misleading the court. Russia requested the transfer of criminal proceedings in October 2019. That is more than 5 years after the downing of flight MH17, and only after 3 Russian nationals had been indicted by the Public Prosecution Office of the Netherlands. My government is of the view that Russia should have effectively cooperated or carried out its own effective investigation long before Russia requested the transfer of criminal proceedings. So my government considered that the transfer of proceedings to Russia was not in the interest of the proper administration of justice. And various considerations were taken into account. First, not only was it considered unlikely that Russia would start a serious investigation, it was also considered very late. Russia's request came 5 years after the start of the criminal investigation by the Joint Investigation Team into the downing of flight MH17. Russia had failed to effectively cooperate with this investigation and had failed to carry out its own effective investigation. It's hard to believe that all of a sudden Russia would start an effective investigation on its own accord. Second, by joint decision of the states participating in the Joint Investigation Team, it was decided in 2016 that the prosecution of persons involved would take place in the Netherlands. And since then, logistical and financial arrangements had been made with a view to the trial that started in March 2020. And third, my government felt it important to take into account the position of the next of kin, and in particular, their right to address the district court. Mr. President, members of the court, I will conclude. It has been more than 7 years since the downing of flight MH17 over the east of Ukraine. It has been more than 7 years that 298 innocent persons lost their lives. And it has also been more than 7 years without someone taking responsibility for this. During all those years, my government has committed itself to pursue truth, justice and accountability for the victims of the downing of Flight MH17 and their next of kin. And the hearing today is an important step in this quest. During the past 7 years, my government has also been confronted with the continuous attempts of Russia to create confusion and distract from the truth. However, the core of this case is the question who is responsible for the downing of Flight MH17. And in its application, my government has set out in detail the involvement of Russia in the downing of Flight MH17 and the related violations of the Convention. As set out in its application, subsequent memorials, and today, my government is convinced that Russia is responsible for the downing of Flight MH17. Without Russia, Flight MH17 would not have been downed. My government is grateful to the court that its application has been taken up by the court expeditiously and with due diligence. And today, an important step is taken in the proceedings before this court. We stand ready for the continuation of the proceedings and the start of the merits phase. We urge the court to continue its diligent approach to our application. This is extremely important for the next of kin that already have experienced tremendous grief and suffering. I thank you for your attention.
Thank you very much, Mr. Lefebvre. I thank all participants, the parties, for their submissions this morning. The court will now deliberate on the admissibility of this case, and a decision will be adopted at a later date. I declare the hearing closed.